which I have now clicked. And as a result, our friends over on YouTube should be joining us very shortly. And if you do want to ask questions or comments or engage during this stream, the best way to do so is over on YouTube. The nature of how the back-end platform works just makes it a lot easier. And as a result, I can look at those questions as they happen, and then the questions get stored on the screen, and I don't have to chase them around, and Twitter or X makes that a lot more difficult. That said, good morning. Let's take a look at what's going on in the lead up to this 10 a.m. hearing. We'll take a look at the motions that came in overnight. Lisa Cox, it's great to see you. Good morning. I know some friends will be joining us over on the YouTube in the next few minutes, so I'll give them a few seconds to join on. But beyond that, let's talk a little bit about what's going to happen at this 10 a.m. hearing. Let's talk about what motions I anticipate will be up for discussion. Let's talk about what opening statements are going to look like next Tuesday. Let's talk about the fact that we have a jury, 18 people, 9 men, 9 women. There will be 12 deliberating jurors and 6 alternates. And opening statements are projected to start next Tuesday, which was a mutual request of the defense and the state, who both had the opportunity to discuss to start opening statements either this week or next week. Monday is, of course, a state holiday in Massachusetts. It's Patriots Day, and it's also, I think, Evacuation Day, maybe. But in particular, it's Patriots Day. So if you are interested in why the opening statements are starting Tuesday, it's not on any unnecessary delay. It is simply a result of the fact that Monday is a holiday. Good morning, Dev Otter. It's so great to see you. I'm doing wonderful. I'm thrilled you're here. I don't know if I'm a chief. I'm just a towel. Busty DD, great to see you. I don't know who was first, but Busty DD, you have been promoted. Welcome to the fold of honorary towels. Good morning, Mona Lisa, Arizona. Julia T, great to see you. Goldie Lawrence, it's always so wonderful to see you. I think your name is a ray of sunshine, as are your emojis. Christina, good morning. I'm glad you're drinking your coffee and you have your water pipe before work. Good morning, Special Towel, says Cookie Ramlall. It's great to see you, Cookie. Lisa Cox says, so happy they got the jury set. I think that's the lead of the day. Our jury is set, and in the lead up to this 10 a.m. hearing, what we're really talking about is what motions are going to be discussed and what final matters, housekeeping or otherwise, need to be settled up in the lead up to opening statements in the Karen Read and John O'Keefe retrial. Karen Read, of course, is charged with 3 separate indictments, second-degree murder by way of a malice second-degree murder by way of a recklessness mens rea, which means in this case someone doing an underlying reckless act that does not require intent to kill. To wit, based on the evidence in this case, Karen, while drunk with a BAC between 0.13 and 0.29, backing up her car to 24.2 miles an hour at 12:31 as it turned over to 12:32 a.m. on January 29, 2022, with that car reducing to 23.7 miles an hour in a millisecond, and a turn of Karen's steering wheel indicating a collision with John O'Keefe, who was outside Karen's car. Thereupon, John O'Keefe fell to the ground on a lawn outside of a home on Fairview Road, never moved again after 12:31 or 12:32 a.m., and Karen drove away, leaving John to, according to the state's medical examiner, die in the cold over the next few hours because of the fact that he was incapacitated from a head injury, potentially from hitting the ground because it was cold, coupled with the fact that Karen left John in the snow, which, by way of reddening of John's pancreas, according to the evidence, indicated that hypothermia was a contributing factor along with the head injury to John's cause of death. As a result of that, there's evidence that Karen also around 5:23 a.m. this morning, there's potential evidence that Karen went from John O'Keefe's house at 5:08 a.m. in her Lexus with a broken taillight that allegedly was broken at 12:31 a.m. when she crashed into John. Karen at 5:11 a.m. drove towards Canton Center. She's seen on video. At 5:18 a.m. she comes out the other side of Canton Center towards the railroad tracks heading towards Fairview Road. And there's a strong indication, which could be reinforced by new GPS data from Karen's Lexus infotainment system that is now 8 gigs in size compared to 2.4 gigs in size of the previous data, because of the fact that Karen Read's own expert somehow used the wrong chip reader and only extracted 1 of 3 chips from that infotainment system. And this expanded chip data includes time and place information from the telematics system and the infotainment system, which could very well confirm that at 5:23 a.m. Karen went back to Fairview Road, saw John O'Keefe dead on that lawn, called John, left a voicemail screaming, "John, is that you?" And that was before Karen Read at 5:35 a.m. drove over to Jen McCabe's house, picked up Jen McCabe and Carrie Roberts. The 3 women drove in two separate cars back to Meadows Ave where John lived. Karen dropped off the alleged murder weapon, got into Carrie Roberts' car, and then after 6 a.m., that explains if Karen did indeed go back to Fairview Road at 5:23 a.m. that morning. That precisely explains why Karen somehow in the backseat of Carrie Roberts' car managed to see John's body on the lawn through a blizzard in the dark when the three women arrived back to the scene after 6 a.m. It all ties up, folks. It all makes sense. That explains why Karen had a meltdown. That explains why, at the scene, why she started saying, I hit him, I hit him, I hit him. That explains why Karen said she was going to hurt herself, and that led to her parents sectioning her for threats of self-harm. That explains why her parents feel so guilty and have worked so hard to help her, Karen, because they inadvertently, by sectioning her, that led to Karen's blood being taken at the hospital. And it's that retrograde BAC serum analysis which allowed the state to confirm that Karen's BAC during the time in question when John was allegedly struck was between 0.13 and 0.29. Boom. All laid out as well as I can do it, folks. Let me go back and read some of your comments. I got on a little digression. Potluck says, the famous towel. Good to see you, Potluck. Welcome. Christina says, I hope Arca is settled today. No, Christina, we already know what's happening there. Arca is going to be subject to a voir dire right before their testimony in the middle of the trial. That issue was already resolved. That was when Alan Jackson had a finding of fact on the record that he materially misled Judge Cannoni, including as recently as 2/6/2025 as to the nature of contacts and payments between Karen Reed and the ARCA expert, Karen Reed's defense and the ARCA experts between March of 2024 and at least July of 2024. Now, what's interesting is people talk a lot about how ARCA was originally retained by the federal government, but as part of their now confirmed as closed probe into the death of John O'Keefe, which I think was pretextual as a way to get information like a honeypot about the MSP, and then eventually after a few months led to the DOJ uncovering the cover-up of Sandra Birchmore's murder because Matthew Farwell, a former Stoughton cop, had connections to some of the MSP officers who also used to work in Stoughton who investigated that murder of Sandra Birchmore. And what's fascinating is within 48 hours, according to a recent audit of the Canton Police Department, within 48 hours of the investigation of Sandra Birchmore's murder opening on February 4th, 2021, the Canton Police had proven that Matthew Farwell was at the scene on Friday, February 1st, the night of Sandra's murder around 9:23 p.m. Second, the Canton Police had proven that the maintenance worker at the apartment complex had said that the man who was there that night was the same man who helped Sandra move into her apartment. And third, which is even more damning, in the audit itself, it says that the Canton Police had found evidence that Farwell had told Birchmore or someone that Birchmore was pregnant and that Farwell was upset and that if Birchmore wouldn't get an abortion, Farwell would, quote, handle the problem himself. This is on top of evidence that Birchmore and Farwell had been involved with a relationship dating to when Birchmore was a child, and further that there may have been a ring of victims and cops in Stoughton engaged in such very dangerous behavior. However, for some reason, within 48 hours, despite the Canton Police getting that evidence, as happens with all investigations of this nature, unattended deaths in the Commonwealth, the investigation was fully transferred to the Massachusetts State Police Unit detailed to the Norfolk DA, the same exact people who investigated Karen Reed. And what happened as a result? Somehow there was a finding by the medical examiner in the Sandra Birchmore case and by the MSP that Sandra's death was the result of self-harm. Bullshit. So, tying this all together, that federal probe of John O'Keefe's death that was pretextual, notice how I can do this, ARCA was retained in that context. The initial contract, according to public records, was somewhere in the amount of $36,000. However, public records also confirmed that the payment to ARCA was only $9,000 from the federal government. How weird is it then that in March of 2024, ARCA sends Reed's defense team an anticipated retainer invoice of $26,000, almost the exact amount, $26,633 or something, almost the exact amount deobligated, but plus or minus, I think it's plus a little bit, from the federal contract. And how weird is it that there was a federal protective order in place at the time prohibiting Reed's lawyers and Reed from having, or any side of the state criminal case, from having contact with ARCA? And then how weird is it that there were emails and disclosures turned over eventually when the new DOJ came in 2025, showing that Reed and Reed's lawyers and ARCA had extrajudicial contact in violation of that federal protective order, almost with a wink and a nod from the old DOJ, as if they were pleased Karen and others helped them stumble on to the cover-up of Sandra Birchmore's murder, just to finally get a gotcha on the Norfolk DA, who multiple factions, including the former U.S. Attorney Rachel Rollins, herself forced out of office by the DOJ OIG in May of 2023 because she launched a pretextual federal probe into the Suffolk DA, Kevin Hayden, because Hayden beat Rollins' ally Ricardo Arroyo in the primary for Suffolk DA after Rollins left the seat to go take the position of U.S. Attorney. So Rollins had ran this exact same playbook before. She launched a pretextual probe into Hayden, leaked it to the Globe and the Herald, and then eventually got caught and fired for it. But what's worse is with Morrissey, Rollins had even more reason to go after Morrissey because they had a bifurcated history of tension over two issues. One, Rollins' soft on crime stance. She wouldn't prosecute a lot of low-level offenses. And two, Rollins Rollins was an early adopter of this argument that youthful offenders in the Commonwealth under 25 shouldn't be charged with life terms for murder, or shouldn't be given life term sentences for murder if they were under 25 because their brains are still developing. Whether or not you agree with the merits of either of those two things, it is the origin of the tension between Rachel Rollins and Michael Morrissey, the Norfolk DA, overseeing obviously both the Sandra Birchmore investigation and the Karen Reed trial. So although there was no corruption or otherwise in the John O'Keefe Karen Reed case, what there was a state police unit that I think the feds wanted to investigate, and the feds were happy to give a wink and a nod to Karen with this pretextual federal probe into John's death that's now confirmed as closed because Karen helped them stumble on to this cover-up of Sandra Birchmore's murder. But I think one important element that really ties this all together is that we have to remember how all of this played out. This was under the old DOJ, Rachel Rollins. She also had a guy named Dustin Chow in there as the head of the public integrity section, which is the section within the DOJ that goes after public corruption in the Commonwealth. That guy, Dustin Chow, his wife got passed over for promotion within the Norfolk DA's office under Michael Morrissey in 2015 in the context of a joint prosecution where the state police had given up original jurisdiction to the U.S. Attorney so that they could do federal charges for a murder that occurred in Sharon 25 years ago related to Whitey Bulger, Frank Cadillac Salemi, and Stephen the Rifleman Fleming. Okay, so in the context of that trial, Chow's wife gets passed over for a promotion in the Norfolk DA's unit and office and leaves the office on bad terms. In turn, which is fascinating, Chow goes around, Dustin Chow, to people saying he wants information to burn down the Norfolk DA's unit allegorically, the DA's office allegorically, the reputation of the DA, those associated. Now, how interesting is it then, how interesting is it then that all of 7 years later, in November of 2022, Karen Reed, David Yadetti, and Alan Jackson walk into Josh Levy's office, then first U.S. Assistant Attorney and the man who took over as U.S. Attorney after Rollins was forced out of office. How interesting is it then that Yanetti, who was on Rollins' transition team when she became Suffolk DA, gets into Levy's office? How weird. And then they start this pretextual federal probe. It's almost like Rollins and Chow took out their grudge by proxy on Morrissey, and they were all thrilled, the whole U.S. Attorney's office, that they stumbled onto the Birchmore cover-up, because otherwise that whole pretextual probe into John O'Keefe's death would have left them high and dry in the wind, and it would have been just another example of Rollins launching a pretextual federal probe with no end just to punish a political rival. Instead, you can justify it ex post facto if you're the DOJ by being like, well, we stumbled onto the Birchmore cover-up, same unit. You know, it was a good honeypot. We run those kind of operations. Look at Buffalo Jim and Steve Miller out in Vegas when we were investigating the Crazy Horse 2. We pumped up Steve Miller's blog articles just like we did with TurtleBoy. We drew in tips. We got cooperating witnesses. And although it's a little bit different here because this was a fake honeypot and the investigation into John's death wasn't the actual target, whereas in the situation with Steve Miller, the mob running the Crazy Horse 2 was the actual target. Here was a honeypot drawing tips about the MSP. They got the Birchmore cover-up. You can justify it to the OIG, Congress, keep it all confidential, and say, yeah, the probe into John's death is closed now, but at least we stumbled onto Birchmore. That also explains why in January of 2025, new U.S. Attorney Leah Foley comes in, and it's almost like a Whitey Bulger situation, where U.S. Attorney Foley must have been like, oh my God, the previous DOJ under Levy and Rollins hated cops. They thought they were all bastards, and they looked the other way, much like with Bulger, and they let Karen Reed and TurtleBoy and her attorneys run rampant because it was facilitating an investigation into a larger fish, that being the Sandra Birchmore murder cover-up. Okay, so then immediately, within days of U.S. Attorney Foley coming and President Trump coming into office in January of 2025, all of a sudden, Hank Brennan on January 30th gets this TUI response from the federal government, which is pursuant to this case from 1985 called U.S. XRL TUI v. Reagan, which is interpolated via a section of the Code of Federal Regulations, which I believe is 126.000. But then in particular, you can go to Section 25 of the DOJ Operations Manual, and you can see specifically enumerated how if you want to get, it's like a public information request. If you're a party to a state criminal case and you want information from the feds that may or may not relate to your case, you have to file a TUI request. Well, on January 30th, Hank Brennan, the prosecutor in the Reed case, gets the first ever truly responsive TUI request in the case, and it shows just a header, apparently, of an invoice, according to public court statements, from ARCA to Reed. That was enough for, within days, Hank Brennan to push, and then by February 12th or 13th of 2025, a whole deluge of documents come out showing the invoice from Reed to ARCA that was hidden, the transcripts of emails where ARCA experts with Reed's defense were helping guide their own testimony mid-trial. And that led to the finding on the record from Judge Cannoni that Reed's lawyers had materially misled the court related to those contacts, okay? So that's kind of the full circle on ARCA, but just realize the implications hiding under the surface there are that the U.S. attorney, the new U.S. attorney, Leah Foley, forced those contacts into the open, and the reality is Karen Reed may have been enabled by the old DOJ, and that's why this is the real story. It's a black mass redo of sorts, with Karen Reed reprising the role of Whitey Bulger. Thankfully, I think it's a little less grotesque, but still, Karen Reed allegedly killed a police officer and was enabled by the old Boston DOJ because of this desire to get that MSP unit, and a wink and a nod because some high-ranking officials in the federal government in Boston for the DOJ under the old administration hated Michael Morrissey, the Norfolk DA. Now, let's tie this into one more thing before I move on to your other comments. Do not forget that TurtleBoy and Rachel Rollins, the former U.S. attorney, had a connection. Aidan TurtleBoy Kearney and Rachel Rollins had this weird connection dating back to the 2020 Senate race between Joe Kennedy Jr., a former representative, and Ed Markey, then senator. Okay? For some reason, Rachel Rollins and TurtleBoy were talking directly about sending Rayla Campbell, a Republican operative, into Joe Kennedy Jr. campaign events to sabotage the race, probably to help Markey win. Now, you might think, okay, that's weird. Why would they do that? Rachel Rollins is a liberal. Rayla Campbell's a Republican. TurtleBoy's basically a Republican. Why would Rachel Rollins ever work with TurtleBoy? Well, maybe the Biden White House had an incentive through Rachel Rollins to make sure Joe Kennedy Jr. lost that race. Joe Kennedy Jr., who would have gone from the federal House of Representatives to JFK's old Senate seat and been on a very similar trajectory to JFK and potentially could have challenged Biden in the primary in 2024. Okay? How interesting. And how interesting then that Rachel Rollins gets appointed as U.S. Attorney right after all that goes down. A thank you for helping preempt a primary challenge in 2024 against Joe Biden. And for the party, the Democratic Party, I'm apathetic about this, but for the Democratic Party, Joe Kennedy Jr. being in that primary instead of the catastrophe with Biden and Harris may have actually been a little bit better for America. But anyway, yeah, tie that all together, folks. It's not just ARCA. ARCA is just scratching the surface of the larger picture here, and the material withholding of the payments and the contacts between ARCA and Reed really just spells out this. It's like an iceberg, and underneath is this whole sort of hidden story about how the old DOJ was in a proxy war with the state police. And don't even get me started on how I think the state police in August of 2023 found out that Birchmore, the cover-up, was being investigated, and then started to look into that and tried to I don't know if it's obstruction or whatever it is, but tried to start asking people, journalists, reporters, people close to TurtleBoy, Lindsay Catani, what the federal probe was about, and I think that's what this is. It was never about John O'Keefe's death. People were really worried about their exposure because all the noise on the Karen Reed case inadvertently exposed the cover-up of Sandra Birchmore's murder. So if you want to know what's really going on, that's what I think is really under the surface here. ARCA, all that stuff are just distractions. And really, there is a big story that no one is really talking about with the DOJ, Reed's team, proxy war, state police, the unit attached to the Norfolk DA, but it's all coming to light. Matthew Farwell already got arrested. All right, so give me 1 second, because I, being a towel, spent a substantial amount of time giving you all that history, and I appreciate you all listening. And now I'm going to go back and read some of your comments. We have 50 more minutes until the top of the hour when the Karen Reed trial hearing, motion hearing, which could involve finding out whether Aidan Kearney will be a witness and therefore forced to miss the entire trial due to a sequestration order, will happen. And then we will also talk a little bit about how the pretrial motions from Kearney and journalist Gretchen Voss are so different. They're both on, well, Voss is on the witness list, but is now confirmed as not being called as a witness. But why Voss is obtaining a stipulation that all the recordings of Karen Reed that are going to come into evidence related to Voss's discussions with Reed and her lawyers are authentic, why that is different than Kearney's argument where he's trying to invoke his Fifth Amendment right to avoid being called to testify against Karen. Kearney is, of course, charged with multiple felony indictments related to wiretapping, witness intimidation, and otherwise as to Karen Reed trial witnesses and journalist Lindsay Cattani. 19 or so open felony indictments across Norfolk Superior Court and Stoughton Superior District Court, and then also an open misdemeanor case for an RO violation dating to 2/26/2024 involving Lindsay Cattani. Okay, so Aidan Kearney has invoked the Fifth. Now, I'm not a lawyer. I'm not your lawyer. This is not legal advice. I'm a towel. Get a lawyer if you have questions about the law. However, what's going to probably happen, I'm just predicting, is I think because Kearney invoked his Fifth Amendment right, there's this process in Massachusetts called a Lumen-Martin hearing, LUMEN-MARTIN. And in a Lumen-Martin hearing, basically what happens is it's a closed-door proceeding. The courtroom empties. Kearney's there. The parties are there. And the judge has to approve Kearney taking the Fifth. Now, that doesn't mean Kearney won't be on the witness list, and it is not a way to avoid being called. It just is a procedural step that gets invoked when you assert the Fifth Amendment. Now, in this context, Kearney asserting the Fifth Amendment opens another door, which is the potential for Hank Brennan to give Kearney a compelled grant of immunity, where whether or not Kearney wants immunity, Brennan can go to the judge, make an application. He has to give every other DA and the special prosecutors on Kearney's case, Ken Mello and Robert Cosgrove, an opportunity to object. The DAs don't have to actually approve Brennan's grant of immunity, but they have 72 hours to object. If they don't, the judge can grant, because witness intimidation and wiretapping are both within the confines of 20E, which is this, I think it's 234-20E, which is the compelled immunity statute. Because if no one objects, no other DAs, Brennan can go before Judge Cannone, and then Judge Cannone can issue a compelled grant of immunity. It's narrow. It's not full immunity. It's just on these limited charges and issues. And then Brennan can put Kearney on the stand, and then Kearney cannot invoke the Fifth. And you might say, okay, well, what does that mean procedurally? And that means that Brennan would call Kearney up there, and then it's kind of like Little Woody or in the Young Thug trial, or Chelsea Manning in the federal WikiLeaks case. What happens is that the judge will say to Kearney, you, outside the presence of the jury, you must answer these questions or I will jail you through the pendency of the trial, because the judge can jail Kearney under contempt provisions to compel his testimony, only as long as needed to compel his testimony. So you could end up in a situation where Kearney gets a compelled grant of immunity, and then he cannot assert the Fifth. His only option at that point is to go up there and answer the questions that Brennan asks about the communications between Karen Reed and Aidan Kearney that occurred between April and May of 2023 via intermediary Natalie, and then that intermediary relationship ended in June of 2023 because apparently Natalie called Karen at night about something and Karen didn't like it. So then Aidan and Karen started talking directly, 189 calls totaling 40 hours, multiple direct messages, 29 calls each, I think, between Kearney and David Dinetti and Kearney and Alan Jackson, Reed's lawyers. And then so all of that will be the subject of testimony, and Kearney can either answer those questions or go to jail. Now, one more interesting thing to remember is, folks, do not discount the timing of Aidan Kearney potentially being investigated for wiretapping involving a woman named Natalie Haskins or something. There's a lot of people from Rhode Island involved in these stories with TurtleBoy. But this in particular, this woman in May of 2023, April or May of 2023, Kearney was telling Karen Reed in leaked messages that he had a problem that was, quote, needed to be solved. It's in the Karen Reed search warrant affidavit for her phones from January of 2024. And if you look into what Kearney was talking about, he doesn't say it directly, but I think Kearney went to Alan Jackson for help with that wiretapping issue with Victoria Haskins, with the woman from Rhode Island. And then the FBI, I have reason to believe, directly intervened in that criminal proceeding. And I think it was because TurtleBoy and the feds and Alan Jackson and Reed worked together over the summer of 2023 to run this honeypot operation to get information through TurtleBoy's blogs, which were artificially inflated as to their influence through search engine optimization techniques by the FBI, same technique they used with the Crazy Horse 2 investigation with Jim Miller in the early 2000s, okay? I think that's exactly what happened, and I think TurtleBoy's favor that he got in response was the wiretapping charges got dropped. But then, once the Birchmore probe kind of happened, you could see TurtleBoy was like, I don't think there was a cover-up of Birchmore, whatever. TurtleBoy became useless. And that's why by December of 2023, when TurtleBoy got his bail revoked, he was begging, reportedly, people for Leah Ferreira, the FBI agent who's in the public integrity unit, begging people for her cell phone number, and people wouldn't give it to him, and he couldn't call her, and the FBI couldn't save him from bail revocation. And that's also why on December 27th or December 26th, 2023, Tim Bradle, Kearney's lawyer, stood up in open court in front of the judge and was like, we tried to talk to the FBI this morning about this, judge. You know, like he was hinting at it, but the judge wouldn't bite, and Kearney's bail got revoked because of Kearney's actions on the night of 12/23/23, which of course is what caused the eventual falling out between Karen Reed and Aidan Kearney. Kearney went to Lindsay Gattani's apartment. The reporter, Kearney, had leaked information to Gattani over the fall of 2023. This is all in the search warrant affidavit for Karen Reed's phone. Kearney had leaked information to Gattani over the fall of 2023 after Natalie was out of the picture, indicating that Karen Reed had a direct relationship with Josh Levy, the then U.S. attorney, and that Karen Reed was getting ex parte information about the federal probe from Josh Levy. And so Kearney went over to Lindsay Gattani's apartment because after Kearney got indicted, he got charged originally in October of 2023 with 16 counts of witness intimidation and picketing a court or a juror, and then some counts of conspiracy. Those all get bound over by a grand jury on December 20th, 2023. All right, and this timeline is very important because you've got to pay attention to these details or nothing will make sense. The indictment comes down for Kearney related to intimidation of the Reed trial witnesses on December 20th, 2023. Days later, on December 21st or December 22nd, Kearney gets news via Lindsay Gattani that she has been subpoenaed for a grand jury, which could only be, clearly, in my opinion, into Karen Reed and Aidan Kearney, because Kearney had already just been indicted on the prior charges, the 16 prior charges. So what does Kearney do in his infinite wisdom, according to police reports? He goes over to Lindsay Gattani's apartment on December 23rd, 2023, and then he tries to allegedly get her to not cooperate with the grand jury, accept a lawyer that he'll pay for her, and then he tries to find out what she had been talking about with certain agents and otherwise PIs that were close to the Commonwealth. And then, as a result of going over there's an incident where Kearney writes down some notes about what Lindsay had been talking to with one of these PIs for the Commonwealth, what she had been talking about with that PI. And maybe not for the Commonwealth, but a self-reported PI. And Kearney, on Lindsay's notepad, writes down notes about what Lindsay had been talking about. Kearney puts Lindsay's notepad down. Lindsay takes her own notepad, okay, which is her property, and puts it in her shirt area. Kearney gets so frustrated, according to police reports, that he tries to get it back, and in doing so, allegedly knocks or pushes Miss Gattani onto a couch. Now, during that whole incident, things are very intense. Kearney eventually leaves, and then apparently he crashed his car driving home early in the morning. Mind you, he'd been having an affair on his wife, who then divorced him. It was a very bad situation. And Karen Reed, according to Aidan Kearney's own leaked messages, said that the reason she cut him off is because she told him not to go to Lindsay's that night. He went anyway and then got arrested. Kearney was a self-declared fugitive and said that the last time, at a certain point, Kearney said the last time Karen Reed talked to him was December 24th, 2023, Christmas Eve, and Reed was upset at him. Didn't say Kearney was mad. She didn't console him, and then Reed told him that he was going to cause a distraction and that he shouldn't have gone to Lindsay's. Now, March 4th, 2024 comes around. Kearney gets released February 26, 2024 from jail after a 60-day bail revocation. Reed ignores him at a hearing on that day or around that day. He might have got released February 23rd or something, but there's a hearing in the Reed case on February 26th. She just walks by him and ignores him. Alan Jackson puts his arm around Reed's back and guides her away from Aidan Kearney. But the fascinating thing is on March 4th, Karen Reed sends a text to someone that was leaked saying that Aidan Kearney is a risk and that Karen is upset at Aidan because, quote, the state police only got Karen's phones because of what Aidan said to Lindsay. And then there was this massive smear campaign to target Lindsay Gattani, which involved like certain YouTube channels like running the names of her kids and stuff to try to bait her because I think Lindsay has information that's both detrimental to like the state police unit attached to the Norfolk DA in the context of, in particular, how Lindsay's cell phone extraction, a 15-year record of that cell phone extraction, was taken by Brian Tully, manipulated while in state police custody to remove messages from Tully to Lindsay and from Kate Peter to Lindsay, and then leaked, including personal family moments dating back to the birth of Lindsay's kids, leaked to Aidan Kearney by Tully directly, leaked to Aidan Kearney's lawyer by Tully directly by hand. Okay, and I think Lindsay Gattani became inconvenient to both sides, despite the fact that it is Lindsay Gattani who really ties together why Aidan Kearney and Karen Reed's relationship was a byproduct of this larger conflagration, Whitey Bulger-style FBI operation to target the Norfolk DA. And if you're thinking, Grant, that's ridiculous. Well, it's not. There's primary source documents. You can find them on my Twitter. I'm reading them from memory because I know them all. You can find them on my Twitter. Every single thing I said can be cross-referenced. Every single source, every citation. I could read page numbers for you if you want, but it's all there. It's all laid out. Every single thing I said, I truly believe is a reflection of the latent factual record hiding under the surface of this God-forsaken case. And I appreciate you all giving me the time to go on that soliloquy. It truly matters to me that the battlefield of this case not only disgraces John O'Keefe's memory, but that the political proxy war between the former DOJ and the Norfolk DA resulted in innocent voices, unheard screams littering the battlefield. These people need support. The best thing you can do at this moment, folks, is go support Lindsay Gattani. Support her fundraiser. Help her in her fights that she has going on. And I'm actually going to share that in the chat right now. Please share this fundraiser. Please try to help Lindsay Gattani. She is such an important part of this whole story, and her voice is being forsaken because she was inadvertently exposed to information that directly exposes misconduct by both sides of the Karen Reed and John O'Keefe prosecution and both sides of the TurtleBoy prosecution. So please, folks, if you have the opportunity, I just shared the GoFundMe in the comments. I hope you folks will check it out. And actually, let me type an actual comment with this GoFundMe. So I'm actually just sending one more comment because I want to pin this one. But I really hope those of you will watching, forget about me. Please take this opportunity to support the unheard. Please. It's not about us. It's about the people who had to live these experiences and whose, as I said, unheard screams litter this battlefield and disgrace this justice system, which I, as a towel, thought was supposed to engender and protect the most vulnerable. But instead, it turns out it's just this nonsensical, high school-esque political proxy war that is more so defined by self-interest and people using legalese as veiled cover to extract revenge on each other than it is about upholding the sanctity of the process or the rights of the most vulnerable. And I'm disgusted by it. And maybe some people in this system have an opportunity to redeem Towel's faith in the system, but by God, I'm just heartbroken. And if there's anything you do today, forget about me. I don't need it. I will get through. I will do whatever I need to do. Please support Lindsay, who is a single mother of just a wonderful human being who got caught up in this proxy war entirely inadvertently, but due to her ethics and her integrity, was able to tread the path, stand on her own 2 feet, and speak her truth, and she suffered needlessly for it as a result. And it is always the good people in our society that we force to suffer because they're not willing to play the subversive, insidious political games and promote themselves and do the other nonsense that makes this country so dangerously on the verge of a collapse into a very scary form of tyranny. And I'm not talking politically, I'm talking due to our self-interest. So please, I beg of you, if you like Towel, if you watch these streams, and if you want to do an act of kindness, consider looking at the pinned comment. Consider donating to Lindsay's fundraiser. Consider raising awareness about her cause. Consider raising awareness about her central role in exposing the relationship between Karen Reed, Aidan Kearney, and the former DOJ in Boston, and this ungodly use of the now confirmed as closed federal probe into John O'Keefe's death to look into the MSP unit attached to the Norfolk DA, and why it is important and it is central to our democracy that it not matter who your friends are or what standing you have or what parties you attend or how much money you have, but simply because of the authenticity of your voice and your experiences that you are valued. And if there's anything you do today, you can say it in the comments. You can say it on Twitter. But let Lindsay Catani know that she's valued. That means a lot to me. And I told you that whole backstory to explain why I'm not saying this gratuitously, but instead as a reflection of my authentic perspective as to the importance of honoring people who do not stand a chance because of their pure goodness of heart to fight on a battlefield that is defined by insidious manipulative tactics. So please, give them a chance and become their voice. That is the most noble act of service you can do. Thank you for listening to Towel. That was important to me. We are going to talk a little bit more as we head into the 10 a.m. hearing about what I expect. I just obviously laid out why I don't think TurtleBoy is going to be exempt from the sequester hearing, but do watch for the judge to motion for or hearken for a Luman Martin hearing if because Kearney indeed has invoked the Fifth Amendment. Now, you want to see confirmation of that? Well, all we have to do is go, well, I have it up somewhere, but needless to say, I will read some of your comments. By the way, this, it says it has no sugar, okay? 0 sugar. It is Kool-Aid, a Kool-Aid energy drink. I do not know how much caffeine this thing has. Oh, it has 500 milligrams of taurine, 500 milligrams of choline bitrate. That doesn't sound healthy. And 200 milligrams of natural caffeine. Okay, so do not give Towel 1,200 milligrams of these 3 chemicals because this is just absolutely unnecessary. I realize you're now seeing what it is like to actually be in my mind unfiltered and actually see all the documents as I'm processing them and relaying them. But just know that it's a lot on Towel's brain. I would rather see the documents 3 or 4 ahead, process my thoughts and relay them rather than having to say it all in real time. Too much caffeine. All right, let's scroll back. Diana Natali, great to see you. Potluck, welcome, as I said. Macy, I agree. If Karen went back at 5:23 a.m., I don't know if it necessarily goes just to second-degree murder, but it goes to leaving the scene. Consciousness of guilt, too. Goldie Lawrence says, love you, Grant. I'm at work, and I'm a chef, so I can't be in the chat as much, but I like listening. Well, you certainly picked a moment to tune in, that's for sure, because I had a lot to say. Karen said yesterday, come at me, Hank, and Hank said, your wish is granted. I agree, Angela Whittick. A cooking towel, says Deaf Otter. We do love cooking towels. We love all towels. I love how Judge Cannoni silenced the defense lawyers and Pinky's outside the court at last. Yes, Potluck, you have wonderful comments. Lisa Cox says TurtleBoy needs to go to jail. Angela says, funny that Hank's coming for you, Karen Reed, and your clowns. Yep. Grant, what motions are being discussed this morning? Oh, Eva, I just mentioned them. It's going to be probably the TurtleBoy motion, the Gretchen Voss motion to get off the sequester list, wrapping up any housekeeping. As you all can see, there's a lamp in the top left. When that lamp shifts to Judge Cannoni around 10 a.m., we will be ready. Karen and her dad act like it's a fight, saying, bring it on, like they are thugs. Yeah, they're aristocratic thugs. I don't know. If the Rothschilds don't consider themselves aristocrats, maybe Karen Reed's not an aristocrat. Maybe I'm misusing the term. She's a upper middle class woman who thinks too highly of herself, as do her family members. Okay, Dewdrops, you have strong opinions. Towel is on spin cycle this morning. Towel is revved up and ready to go due to this ridiculous energy drink that I will, although I think it tastes nice because it's Kool-Aid, I will never buy again. That is, I don't know what that was, but I don't need to ever relay that much information that quickly ever again. Wall of blue towels. Good to see you, Drew Drops. He's a scrouge. Turtleboy's a scrouge to humanity. Hi, Lazy Susan. It's so great to see you. Welcome back. We're waiting for 30 more minutes or so to start the 10 a.m. hearing. Towel will not be able to keep up with chat. It's moving so fast. Yeah, I'm a little bit behind. Yeah, Tom CPU, I don't believe is actually at court today, so I watched him a little bit earlier. They were just talking about Olivia Lamb, whose mom, Christina Lamb, does boutique consulting for law firms, and I'm pretty sure they were doing PR, and Olivia just got caught up, and even though she's probably not getting paid anymore, I think it's very possible she was pot committed, and yeah. So I don't know. Olivia's smart though. I would have a discussion with Olivia. I just realized I just wasted 15 minutes trying to explain why DePetro's question about OJ was relevant. They called him inappropriate. No, that was a great question from John DePetro about Karen Reed invoked OJ, and that was ridiculous in the Vanity Fair article, and therefore John DePetro asked Karen Reed a question, and it was a good question. Claiming ownership of the beach towel. You absolutely can be a beach towel, Julia T. Dewdrop says Team Hanks. All right. Grant always said TB. Grant, Eva says, always said TB was possibly a CI. It's the only logical reason he's not in jail. Yeah, him and Kate Peter, huh? TurtleBoy for the feds, Kate Peter for the state police. Oh, thank you all so much for all of your wonderful words and support. Potluck says Lindsay's a nice person. It's a shame she got entangled with TB. Yeah, I agree. The same says Grant, says Angela Wittick. Soleil Nina said, notice how I remembered that? Says, yes, speak the real truth, Grant. Well, God bless you. Towel's doing everything he can. As I said, consider checking out the link that's pinned up at the top of the comments. Consider giving Lindsay some support. Towels, by God, they come together in support of the vulnerable, and we can do it, friends. We can do it. Let's see. Hey, Jay says, fire Tully and hope Lindsay sues for her civil rights. Oh, I think I know who you are. I'm blocking you now. I'm going to make sure it's you, but I don't want you here. You're a dangerous, subversive person. Mods, I don't like that J person. They are dangerous. I don't like them. Grant knows the underbelly of mass politics. Yeah, I would say Grant's a little enmeshed because of his Cannabis Control Commission reporting and legislative reporting in the mass political structure. I'm not really a partisan. I'll critique Democrats, I'll critique Republicans, I'll critique nonpartisans. I'm more of like a watchdog. I really believe in the integrity of America. My principles are country, God, family, or safety, country, God, family, in that order. And I care a lot about this republic, and I care a lot about the people I love. And I express that all the time, and I'm unabashed about it. And I don't think love is a bad thing. I think I think love is a beautiful thing. And we are a society that is becoming far too transactional with our relationships with others, and we should refocus it on unconditional love. And we also should embrace love as the highest form of human beautification. It is literally the apotheosis of humans with the non-temporal, and it turns us into a very special thing. So not forsaken love or just purely physical love, but actual love is a beautiful thing, and I think we need more of that. And Tao will not feel bad about that. I am proud of that. So happy when I saw you live this morning, says D Nice. Thank you for all you do. Well, thank you, D Nice. It's always great to see you when you join in, and I can't always react in real time, but I will for this. We're waiting for the 10 a.m. notice. Waiting for the 10 a.m. Beginning of the motion hearing, which should be about Aidan TurtleBoy Kearney being on the witness list and things like that. There's no major developments that have occurred since we've last talked to each other. It's just some perfunctory motions about the use of videos during opening, although those videos of Karen's interviews that she gave to Investigation Discovery and HBO Max, 400 hours of material. There's 41 clips that Hank Brennan might or might not use in his opening. Those are all going to come back to hurt Karen. Her changing story about where she last saw John, about her plucking glass from John's nose. It's all going to go before the jury, and it's going to be brutal. Jewdrop says, justice for John O'Keefe and his family. Angela Whittick says, what did the beach towel say when it won the lottery? I'm feeling so much richer now. Angela Whittick always makes jokes when things get intense. Everyone knows Karen is guilty, says Lisa Cox. Well, you're entitled to your opinion, and I happen to agree. I think Karen is guilty of killing John O'Keefe. Melanie, unfortunately, I have class throughout the next few weeks, and I'm in finals, so I have to go right from coverage of the 10 a.m. hearing today to drafting my first final. And first of all, there's no way I could have got there early because I didn't even finish with the work I was doing earlier until right when we started the stream. And then I don't have time. I cannot spend time waiting there and then get back home, or I will not be able to get my work done. And I need to get through May 14th or something. I need to get through these next few weeks. So I'm doing these streams. One, because when I'm down there at court, I could do these broadcasts, but it's a lot harder. I'd have to find a place. There's a lot of tech. I can sit here, we can watch the motion hearing, and I can do the broadcast, and it's more important in some ways than reporting in there because the feed is delayed, and I cannot clip in real time and do analysis and sit in court. So there's a lot of reasons, but mostly because unlike the last trial, which started late April, early May, when I was ending my term, this is still term going on, and that's what's important right now for me. Oh my God, I see Murder by Maestro. That always brightens my day. I see Murder by Maestro in chat. I smile because I'm a towel. I'm so glad you're all here. Yes, Jay, and the mods will summarily remove you because all Towel has to say is you're dangerous, and that's enough of a sign that you won't be back. No, I don't. I know. Syntax is a very strong indicator, and you only have to say one thing. Murder by Maestro, this chat is missing without you, is always missing, is not the same without you. Grant has more mods than a towel sale at Macy's. I love it. Let's see. Jay, what do you want here? Just to listen. All right. We'll see about that. Yeah, I do think Jay needs a little attention, and Jay only has to use a few more words for me to know exactly who Jay is, what they want, and why I don't want them here. John O'Keefe would want us together. Yes. Well, I don't. Wait a minute. Hold on. I can't speak to that. I don't know. Maybe I would have to ask someone who knew John that question, and then I would relay what they told me. But I can't answer that. Good morning, Kim Courteau. It's Crotu. I'm not great with. I need phonetic pronunciations. But good morning. I rushed to get on for this. Murder by Maestro. I'm thrilled you're with us, my friend. Truly, you warm little towel's heart. Let's see. Well, Jay, you can listen all you want, but yeah, depending on the word choice you use and who I think you are, we can all just summarily remove you, and you're outnumbered 50-1. And the towel, I wouldn't say there is no hive mind here, but there's definitely a sense of the shared ethos, which is rooted in not being derogatory, not being discriminatory, and not sea lioning. And you were so close with your first comment to sea lioning, and your syntax was so identifiable that I was just like, nah, fuck this guy. And I'm entitled to be like that because who cares? I don't care what you think, and I don't care who you are. Grant is like Frodo, but with a CR. I only got the first part of that reference. We shine together, Murder by Maestro says. I agree. All right, I'm caught up on chat. So let's take a look. Where do we got here? Let's take a look at this recent state notice of discovery. Oh, what? Why didn't it come up on the screen? I know why. I know why, because I'm a towel. Oh, 1 second. There we go. Give me 1 second, folks. I remembered that as useful as it is to bring all the documents up on screen, I have to actually keep track of where those documents are. So watch this. No, that's not what I want. I want this. There we go. The magic of computers. Now let's take a look at that, shall we? What does that say? That is the new discovery just turned over. And what is hiding? Number 14. The state has 41 video clips of Karen Reed's statements. It's not good, Karen. It's not good at all. And what's this? Oh, is this Aidan Kearney's motion? Where if we scroll down, oh, hold on. Oh, no. I have this water bottle cup on the side of my chair that is not very effective, and I need to get a new one. Hold on. Effective towel. Hold on one more second. Other creators run like these back-end GUIs to do their streams, and I'm like, no, I will use a professional streaming software if it kills me. All right, here we go. Let's take a look. What does this say on page 8 or 9 of Mr. Kearney's motion that could be discussed today? By the way, this is one of the motions I think that's going to have to be discussed today because it's outstanding. Mr. Kearney's motion to be not kept away from the entire trial. He's not going to win this motion, by the way, in my opinion. But what does it say right here? Point 15 on page 8 and 9. In these circumstances, as attorneys for Mr. Kearney, we have no choice but to inform the court that if Mr. Kearney were to be called as a witness against Ms. Reed, due to the proposed subject matter of his testimony and the circumstances described above, on advice of counsel, Mr. Kearney will assert his Fifth Amendment privilege and refuse to answer any questions. Now, Bradel, his lawyer, is wrong about this next sentence, in my opinion. This fact, without more, should exempt Mr. Kearney being subject to the court's order for sequestration. Nope. Brennan's entitled to call you up there with a grant of immunity or call you up there and make you assert the Fifth. Doesn't get you out of it. That's why Lumen Martin hearings exist, Mr. Kearney. I feel like I'm saying that wrong. I don't care. I'm also eating Cheez-Its. Sorry about that. I'm a hungry towel. What do you want from me? I don't get to really eat for 20 minutes. All right. Now, we looked at that from Kearney. We looked at that. This is Gretchen Voss's motion. All right. Now, Gretchen Voss's motion is different. I mentioned it earlier. Gretchen Voss, I don't think, will be sequestered because neither side opposes this motion. And Voss was informed she's not actually going to be on the witness list, and they're going to stipulate to the validity of the recordings. Now, Voss has recordings, apparently, according to prior state motions, of Reed saying that David Yannetti told her she had criminal culpability if she backed into John, and that was within like 3 days of Karen allegedly striking John on 1/29/2022, before Karen was initially arraigned in Stoughton District Court on February 2nd. She was arrested February 1st, arraigned February 2nd. And that's also when David Yannetti was saying things like, my client had no criminal intent. Furthermore, Voss has a recording from July of 2023 at the Omni Seaport, according to prior public court motions, where Alan Jackson proposed to Voss that Alan Jackson would leak federally or state-protected documents to Brian Walsh's lawyers, probably about Michael Proctor, who was an investigator on both the Walsh case, which is another case in Massachusetts about this guy who murdered his wife and is on trial for it. Same MSP unit investigated that. No corruption in the Walsh case, though, open and shut, in my opinion. Birchmore case, definitely potential corruption. Reed case, no corruption. Reed O'Keefe case, no corruption. Walsh case, no corruption. However, Jackson says to Voss, I'm going to give documents to Brian Walsh's lawyer that I can't release, but you can cover them as if you were covering the Walsh trial. And apparently Voss didn't go along with this, but the recording of that plan exists. So that could come in too. But Voss's argument here, you can see, I don't need to read it all for you, but if you're watching on a big screen, you'll see it. It basically just says that Voss, because they're stipulating to the authenticity, given the stipulation to which the Commonwealth and defense have agreed, and in view of the exceedingly narrow scope of any relevant testimony, Voss might offer the public interest in her being able to cover the proceedings, far away any conceivable interest in excluding her from the trial, and then, basically saying that the stipulation to the recordings is enough for Voss to not be a witness. But notice that is very different from Kearney's argument. Kearney is not arguing. Oh, hold on. Did I hear some motion on the YouTube? It might actually just, what you hear as noise might actually just be the courtroom microphones being tested. So I want to give you a heads up as we get closer to 10 a.m. We're going to see this court come into session because the motion hearing today, there's no jury selection. We have our jury in the Karen Reed and John O'Keefe case. But the motion hearing is going to start, and motion hearings are pretty prompt. Unlike the past few days where motion hearings have been a little bit delayed, not motion hearings, jury selection, because jurors have to arrive at court. We are not going to run into that issue today. Motion hearings normally are very prompt. barring extraordinary circumstances, traffic, some kind of catastrophic accident not involving the parties, but like an accident on the way where somebody gets delayed. And people are always like, what happens if you're, an attorney and, you're late for court? Well, if you're late for court because you were late, that's a problem. Hold on. We are seeing a real-time arrival of Karen Reed in court. Hold on one second. Thank you, Law and Crime, for this. Give Towel 1 second here. Let me remove this. Okay. And then let me also remove this one. I'm a functional producer, Towel. If you ever wondered what's it like to be a producer when you put content up on screen in the background, this is what it's like. And I don't do any of that GUI stuff. I do it by hand. All right. Let me click this. Let's see Karen Reed walking into court.
Happy Easter weekend, Karen.
Okay. I wouldn't have made it without your example. He sprinted.
I saw. I was like, why? I
don't know if that was...
That was weird. There was like 3 people. No one there. There was like 3 people. That was the weirdest thing I've ever seen. So Karen is in the courthouse, but look at that scene. It's so ominous and just weird. They're just 4 people. They can't follow her in. They have to stand at the base of the stairs. It's a very weird atmosphere. It is very strange. I want to get rid of this blue bar. I don't like it. There we go. All right. So, Grant, why are we looking at a light bulb? It is the light bulb of incandescence. We shall all become illuminated. Other streams are apparently based on nipple cults. One of the Karen Reed streamers really likes this guy's nipple. We don't really know why. He's a jolly green giant, the guy who streams. I like him. But he for whatever, I don't listen to him. I just looked at him once. But for whatever reason, he has this guy's nipple below him on his stream. And we spent a lot of time analyzing why the Karen Reed supporters like this nipple. And we came to theorize that they are actually an esoteric religious cult based around nipples. Now, I personally think that's a little bit heathenistic and a little bit idolatrous. I don't think you should act like, I think worshiping a nipple is a bit weird, but to each their own. We're a pluralistic society. More power to them. Now there's this other stream. Oh no, there's not another stream that worships something. We were just talking about Chewbacca, and I was saying that Chewbacca should be a good third-party culprit for Alan Jackson to use. So then there was the Chewbacca thing. But now I've decided what our channel, our towel friends, should focus on is this light. This is our guiding light. I don't really know what the light is trying to tell us, but like moths to a flame, like towels to a dryer, we shall go towards the light. The light of enlightenment, friends. Yes, that is why you come on this channel, for the thrilling legal analysis about a light. No, actually, you're waiting for a 10 a.m. Karen Reed hearing, which, to be fair, is actually going to start right on time. So if you're joining and waiting for the 10 a.m. hearing to start, it is going to be a motion hearing. I can actually give you more of a preview now that we've seen Karen Reed walk into court. I can give you more of a preview of what the hearing is going to be about. And actually, we can do it simultaneously. Oh, no, I have blocked out the light. What have I done? But I can do it simultaneously. I can show you the motions we're going to be looking at, which is I guarantee you, the paragraph I am putting up on this screen is going to come up during this motion hearing. I'm almost certain of it. Now, let me take a look at some of your comments, because we only have about 12 minutes to go before the hearing starts, and I want to make sure that I get it to as many as I can. Oh, wow, you all became quite active towels as I was enumerating that last section. Let's see. I did get a little bit behind in the comments. Potluck's like, Jay, just listen like a good boy. You may get a Grant cuddle. That's hilarious, Potluck. Shade Finn says, it seems most people are on KR's side online, so it's nice to see so many people on the side of the fence. To you all, even if Karen did it, shouldn't the effed up investigation result in not guilty. So first of all, Shade Finn, there was no effed up investigation. If you read the Canton audit report, you can see that, if anything, the novel use of leaf blowers was a replication of a technique used up in Alaska. The processing of a crime scene, which was very out of the ordinary in Canton. I think there had been 2 murders in Canton over the past 21 years. Was done to the highest levels of expected standards, and in some sense was applauded by the audit unit for going above and beyond and developing and employing real-time best techniques for crime scene processing in a difficult blizzard-like environment. The 7th worst storm in the area in recent history, by the way. So no, Karen Reed's guilt, if anything, is reaffirmed by the ingenuity of the investigation to process a crime scene in real time, in spite of Karen's fact to cover up her own, in spite of the fact that I think Karen Reed tried to cover up her own crime in real time. That's why she didn't return to the scene in the murder weapon. Along with everything else that happened that morning, I think Karen tried to make it as hard as possible for the investigators to figure out it was her, despite the obvious evidence, and they still figured it out within 72 hours. Kudos to the Canton Police. On that case, kudos to the MSP. Well done. The comments about Karen, I didn't like them, the detectives, but she is alleged to have killed a cop, okay? You are alleged to have killed a cop. You probably are going to get called a lot worse than the names that Michael Proctor called Karen Reed. And I'm sorry, in some sense, to Karen Reed that her disease was mocked. I have the same disease. I don't like that. I wouldn't want to be mocked about it. But it's not just you pissed off the system, but if you are alleged to have killed a cop, people are going to have strong opinions, okay? And you cannot deny that. It's a serious issue. Let's see. Justice for John O'Keefe and his family, says Jew Drops. Always true. Motion will no doubt be denied, says Soleil Nina. I agree. Motion from TurtleBoy to be exempt will be denied. It is interesting that he's asserting so openly that he's claiming the 5th, though. Karen drove drunk, says Macy, hit John and left. She may have gone back that morning and never called 911. Look at what she has done. She needs to be held accountable. I agree, Macy. Potluck says, Jay, we don't care who you are. You're not worth it, chap. I don't think Jay made it very long. Hank Brennan has requested to play more clips during opening, right? Yep, Murder by Maestro. I think those 2 motions should come up today. I actually have one of them that I can pull up on the screen for you right now because I'm a towel. Well, also we have this motion to introduce the extrajudicial statements of Karen Reed, which doesn't require foundation. It just requires that the defendant make the statements, and you can see them right there. That's one of the motions we're going to talk about today. It's going to be granted. It's pro forma because the rules of evidence are so strong on the defendant's statements coming in. But then there you go. There's the defendant's notice to use videos, and there's the Commonwealth's notice. Absolutely, Murder by Maestro. As always, my friend, you asked a prescient on-topic question. And for folks just tuning in, we're only a few minutes away now from the start of the 10 a.m. Karen Reed motion trial hearing, which is what we're really covering today. Jury selection is done. There are 18 jurors selected, 9 men, 9 women. My name's GrantSmithEllis, and this motion hearing is probably the final housekeeping hearing in the lead up to the holidays over the weekend in Massachusetts, the Patriots Day holiday, Marathon Monday. Boston Marathon will be taking place. There was just a wonderful ceremony to honor the victims of the marathon bombing a few days ago, so God bless those victims. And if you do watch the marathon this weekend, keep those folks in mind and honor their memory. But the trial will start up on Tuesday, April 20. Is it April 25th? Right around then? April 22nd. Yeah, got it. April 22nd, 2025, opening statements. And this motion hearing is the final. This is it. This is the final hearing in the lead up to opening statements. So this is it, folks. Let's see. Can't wait for Hank Brennan's opening statement, says Drew Drops. I agree. Murder by Maestro said it's coffee time. I agree. It is coffee time. It's towel time and coffee time. And Towel's going to have his cigar in 1 second here as we all watch this hearing. Then I'm going to go get some pizza after the hearing because I'm very hungry again. I think we will have our answer on the 5:23 a.m. return to the scene on opening statements. What do you think? Macy, I agree with you. I think we could. Potluck says, anyone want some coffee? I'm just putting the kettle on. Potluck, if you want to make up some fresh coffee for Towel, that would be great. I shouldn't be drinking this energy drink. It has far too much caffeine and other chemicals that I don't quite understand, but they should not be in a drink. They might have some use, maybe for like Air Force pilots or something, but they should not be given to towels. If you just tuned in, we started the stream with the most interesting, layered, off-the-cuff towel rant, completely from memory, reading like 70 different documents from memory in a row and tying it together into a cohesive Joycean schema modeled after Hegel's beautiful historical dialectical form, and then it explicated to you all in lay terms as only a towel can do. It was a little much, as Sema might say. It was a little extra. Then again, you are watching a stream operated by a man who thinks he's an anthropomorphic towel, and a man who has a plan to send viewers down to Latin America, his towel friends, in order to start up a towel industry, not to make money, but to artificially get influence in government to benevolently overthrow the world order in the name of unconditional love, and to turn realpolitik on its head, and to switch from a system that glorifies expanding, preserving, and demonstrating one's own power to a system that incentivizes preserving, expanding, and demonstrating one's capacity for unconditional love through acts of service, which I have argued in Towel's philosophy of history is the exemplar of Kant's categorical imperative. It is not do not lie, because you should lie if you're hiding Jews to save them from Nazis, as we talked about yesterday or the day before on this stream. But what you should do is you absolutely should do acts of service from a benevolent place to help others. Nobody can challenge that as a universal categorical imperative. My name's GrantSmithEllis, as I mentioned, and we are just a few minutes away here, 4 or 5 minutes away from the start of the 10 a.m. hearing. Folks are saying it was very nice to not see people yelling outside the courthouse in the lead up to today's hearing. Yeah, it does look like a lonely figure, Miss Reed, walking in looking for her 99 Luftballons of hope amid a cratered Reichenplatz, as her seaport bunker resembles the collapsing Reich Chancellery Gardens. And it is only a matter of time now until Reed's metaphorical defense ashes float up into a setting Berlin sun as the Soviet divisions encircle and shell the last remaining remnants of what once was an empire controlled by Karen Reed and her PR apparatus. The collapse of an empire is always a sad, interesting study, whether one supports or does not support such fall. But it is incarnate the tragic rise and fall of human morality, human societies, human governance, or otherwise, as embodied in one lone, single, solitary figure, fleeting from the world scene and from the memory of the collective public consciousness, Karen Reed, who came to show all of us in America what a sad chapter of the judicial system's legacy will come to look like if these PR efforts run unchecked throughout our country and through the world. Now, yes, in this case, the hordes were fought back by Hank Brennan and the evidence and the new DOJ in Boston, and maybe a little towel did his part, and all the other folks who stood up along the way from a purity of heart in defense of the integrity of this form of government and our system of justice. But this trial has cost so much. It's torn communities apart. It's torn families apart. Yes, people are humbled at this point, and I think the Karen Reed support is decimated, and most people are just moving on. But at the same time, the damage that has been left in the destruction of this case will be talked about for decades. It's not just a modern black mass. It's a modern black mass that tore apart the fabric of Massachusetts. And I'm sorry that as a towel I had to be here to chronicle this, but by God, I will do my best to do honor to the voices of the unheard and to the legacy of John O'Keefe, which also, sadly, was lost among Karen Reed's insidious, selfish PR chaos. Grant, hope you get some pizza before going to school today, says Soleil Nina. You're so kind. That was great. Hot mic of the Law and Crime Media crew talking about Karen and Aidan. The tone showed how they really feel. Yes, that moment yesterday. Us towelettes soak up all the truth, says Dewdrops. Justice for John O'Keefe and his family. Francis Futrell, it's great to see you. I hope the honorary towel tomato plants went well the other day. Your noble act of service became an exemplar that I shared on my Twitter, and I think people really liked it. Francis says, hi, I caught that as well. They treated Kearney like the plague, as they should. Well said, Grant, says Dewdrops. Sole Nina says, thank you, Grant, for all you do and documenting. It's much appreciated. Oh, I do my best. Murder by Maestro says there's a reason. Well, he was responding to me saying there's a reason the cops didn't like Karen. It was because she killed their friend and fled. Most in her position, after killing a cop, they get taken into custody on a stretcher. I agree. And I do, as we're oh, you know what? This hearing is about to start, folks. We're towels. We're ready. I'm going to be with you as soon as Judge Cannoni takes the bench. And in fact, we might even have the ability to skip forward in time because I watched a few seconds of Karen walking in. So how about this? Oh, look at that. We're jumping forward in time. We are time traveling. We're time traveling towels. Time traveling towels. What a great alliteration. Okay. I think I need to invent some kind of time travel machine. Murder by Maestro. I know this is probably stretching it a little bit, but I think it's been proven that time travel is possible based on the moment that the time machine was created. I was reading some interesting article about this the other day. So Murder by Maestro, this is a big assignment, but if we could find a way, we need to figure out two things. One, when was the first time machine invented? And then two, can we somehow harness that technology and tap into that time loop and then go back in time to when the first time machine was invented? I just absolutely, I'm sorry to assign this to you, Murder by Maestro, but you're the only one capable of doing this. I really should have said in hexadecimal binary, but I don't really know how to speak that way yet. I know how to think that way, but I don't know how to speak it. It doesn't really have phonetic pronunciation. You'd be saying like 01XHF410EA. It wouldn't make a lot of sense. One female reporter said of TurtleBoy, oh, I don't care for him. Let's leave. Yeah, let me see if I can pull that clip up, Murder by Maestro, actually. That was a interesting clip. Murder by Maestro always has the best suggestions for clips for us to watch as we await court to come into session. But if you're wondering, you're not missing anything. If you're tuning in for the 10 a.m. hearing, we are watching the live feed from the pool. As soon as that feed goes into session, you're going to see on your screen the camera pan down. We'll know we're in session, and I will turn this over. For now, I'm following up on Murder by Maestro's wonderful request for us to take a look at the video from yesterday of people just ignoring TurtleBoy Kearney, the law and crime reporters, and the camera person, the hot mic. Now let me see, I don't know if I reposted it or if I just came across it at a certain point, but it was an absolutely hilarious moment. It was before, let me see, how did I not repost this? I should have reposted and commented on this. I wonder who actually shared it. I'm normally so good at all these, but I was focused on other things yesterday and I didn't share that exact moment. So let me see if I can find it here. Law and crime. And then I should be able to find it in the latest tab because I wouldn't say like a lot of people use that exact phrase. And we're just looking for the video, this hut mic video of Aidan Kearney walking as we wait for the 10 a.m. hearing to start. It wasn't even Aidan Kearney walking. Oh, is this it? Ah, I found it! Count Basemaster was the one who posted it. All I had to do was search law and crime and go to the media tab on Twitter, and it was like the top video. That is hilarious. All right, Murder by Maestro, you're getting your wish, my dear friend. Everything you could have ever wanted and more. Every time Murder by Maestro requests a video, I'm like, I have an ethical obligation to show this video on the stream, and no one will stop me. All right, let's see. So what are we going to do? We're going to, all right, I got that loaded up, and then I got to just click one button here. Oh, no, we're back to the fan, the nauseating fan. All right, let me do the there we go. At least that's a little better. Count Basemaster put a picture of Mr. Burns. All right, let's listen.
There's no one else to get, like, no one else to get, right? No.
No, that's it.
Okay.
That's the meat and
My
potatoes.
first day here. That's what
Yeah.
I thought. All right. Very
The
good.
father sometimes here.
Okay.
He'll say a couple things. I don't think he was here.
Okay.
There's TurtleBoy, who's kind of popular
No,
too.
I don't. I'd rather not.
Like, and
I
we've already, I think everybody's had enough of him.
No, I don't care. Please. I'm done. There's no one else to get, like, no one else to get, right?
TurtleBoy, who's kind of popular.
No. Okay.
There's TurtleBoy, who's kind of popular
No,
too.
I don't. I'd rather not.
Like, and we've already, I think everybody's had enough of him.
No, I don't care. Please. I'm done.
Ah, that's the funniest fucking thing I've ever heard in my life. Oh my god, I'm not watching that fan spin. That is just miserable. Oh my god. I hope you all appreciate me taking that off, because that is just nauseating. Oh my god. Here, what I can put up is one of these motions, because at least that's at least this is the motion, or this is the motion that's going to be talked about today. But my god, that fan nauseates me. I don't know if I'm the only one. I wish they wouldn't show the damn fan. But either way, we're still going to know exactly when the motion hearing starts, folks, because you're going to hear in your ears the judge to start talking, or maybe the court clerk calling the session, the case to session. Another really astonishing thing is when you speak, you rarely say or ah. You are extremely articulate, almost like you have three minds thinking at the same time. Impressive. Oh, you're very kind, Siguri22. I'm so grateful for your compliment. I don't know if I missed a previous insight you had made in the chat, but that is a very nice thing to say. I definitely try to intentionally not use the word or and I'd rather take a short pause to collect my thoughts than use a filler word. But don't get me wrong, we go past the 4 or 5 hour mark, I absolutely will start to use or pauses to provide myself, as I just did, a little bit of time to speak. I do better in the beginning of the streams. But that was such a nice comment. I'm so glad I got to read that. I don't know if I think of it as astonishing, but I certainly appreciate the feedback. Thank you for broadcasting, says Soleil Nina. I'm always happy to help. D-Nice, can you play the clip of the reporter, which is John DePetro, asking Karen about OJ? Yes, I absolutely can do that, especially because the last thing I want to do is look at this damn fan. We're going to call it the damn fan. All right, I got this clip of John DePetro asking that great question to Karen. That one shouldn't be too hard to find because I keep it on deck. Where is it now? I'm a little bit, maybe there's just a lot of documents being filed right now. That's what's causing the delay, but I can't exactly explain what's going on with the delay in the start of court. It can be due to any number of things. But yes, let me grab this video for you. Of course, I put it in the wrong tab, but that's all right. I can bring in this tab, and it's John's video should pop up. Let's take a listen. This was a great question from John DePetro to Karen Reed.
Karen, was OJ framed? Was OJ framed, Karen? Was there blood in the Bronco? What other killers are you supporting?
Balls. Great questions, John. Love them. Thank you to whoever asked us to show that clip of Karen getting questioned. I think people asking tough questions to Karen's incredibly important. And if you're wondering, no, you're not missing anything. The hearing has not started. They're running a little late. Let's see. Kerry Gold says black matter is malleable. So if you bend point A to point B, time travel, just limited by not having a vehicle that can cope with the speed of light and the body limits, of course. Yeah, so I think I'm not exactly, I'm not well versed in this. I'm not an expert. You should read the actual literature. But what I understand is there is room within the general theory of relativity for there to be a loop. And I think it has to do with how fast you're traveling. Did you ever watch the movie Contact from 1996? That's basically an interpolation of this hypothesis, which is if you travel really, 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 really fast, you can basically experience time slower than it's occurring. That's one way you can do it. And then there's this other theory, which I think also involves a very high rate of speed, where you can technically go backwards in time, but not forward. And you can only go backward to when a time machine was initially created. Now, I'm not a physicist. I don't want to be a physicist. I don't understand that. I don't understand math on that level, and I don't want to. But there are people who are working on this. And the theory, and it does align, I think, with general principles, or I don't know if it breaks the principle of E equals MC squared, or if it pushes it to a new limit or whatever. But there is a principle of this. This is a thing. And I think it's very interesting. Now, I think we should assign it to Murder by Maestro personally, but, I'm just a towel. Let's see. Let's see. The real press is done with Karen. I agree. Macy was like, oh, no, that was epic. I'd rather not. Yeah, it was a great clip. That was Law and Crime. The national press hates TurtleBoy, says Trevor McIntyre. I wouldn't be surprised if that's true. Let's see. Oh, there's no doubt in my mind TurtleBoy saw that clip. It went viral. You got to think, Karen has been begging them to give her press for a year now. Suddenly, all they get is her old man. Yep. Watching that fan could cause an ocular migraine. Yeah, no, I hate watching that fan. We're not going to watch the fan. I don't know why the court pool feed is doing that. Show the clock or anything. Show the light. Rest in peace, John O'Keefe, says Jew Drops. Karen is going down, says Lisa Cox. Must watch the reporters' faces. Oh, yeah. What about that ridiculous... clip? I think Katie Benoit caught it. Or is that her name? The reporter for NBC 10. She was not one of the people being obsequious towards Karen, but Christina Rex, John Hall, and David Bienick from WCVB. My God, could they have been any more obsequious in fawning looks over Miss Reed? It was embarrassing for the local media and just not cool. I don't know why. Maybe it was like starstruck, whatever, but like, why are you smiling at a cop killer? Like, what the fuck? That was my exact reaction. Now, hold on. I have it here. The reason I know that I have this clip is because I actually replied to Katie when she posted it. And therefore, it is in my recent replies, and I can just bring up this video for you. I actually told Katie to watermark her videos in the future. Katie Benoit, I got her name right. That was impressive. All right, so Katie Benoit here is a reporter with NBC 10. And we are going to watch the faces of some of these obsequious reporters being ridiculous when they ask Karen Reed for comment. Look at their faces.
Please, we're loaded for bear, ready to get the show on the road, and we're happy with the whole process today.
Karen,
last 2 weeks.
How do you feel about Hank Martin planning to use your interviews in his opening statement?
Come at me.
That's what your dad said.
I like your dad.
I may have seen it. I would not have said anything that I wouldn't say again.
Are you pleased? Like to have more time than openings Tuesday? Did you guys originally hoping to get more time?
We're ready right now.
Are you happy with these jurors, these 9 men and 9 women?
Pleased.
You've seen
Absolutely.
them up close, and what do you think about them?
They're truthful, and they were questioned thoroughly. So I have confidence in that.
How will you be spending the weekend?
Do you think you might testify this night?
There'll be no comment.
Are you feeling confident about your case?
I mean, I'm bringing the faces up again, but like, what is that? Come on. Like, look at that. Someone got a really good picture of it, but like, they're basically like fawning over her. And listen, I'm not like, I get it. You get in the moment or whatever. She's smiling, you smile back, but like, you're supposed to be. It's a criminal defendant. Like, would you be smiling at John Gotti? By the way, you're still not missing anything. We are waiting for the start of the 10 a.m. Karen Reed hearing. But I am not going to torment you by making you watch this damn fan. I'm not going to do it. This is the worst thing I've ever experienced in my life, and it's nauseating. I wish someone would send a message to them and to the pool reporter and say, please stop showing that. It is making us all rue our existence. So I'll keep that up on the screen for you, and I'll read some comments so you don't have to watch the fan. Let's see. I got to load some new comments. Give me 1 second. Someone said there's a new motion up for Pro Hoc Vice. All right, let's check it out, Chastity. Chastity has informed us that there's a new Pro Hoc Vice document up on the Karen Reed trial docket. So let me pull that up for you right now. And we can search it. Now, we're going to hear that could be the reason for the delay. If you're filing motions, then the judge is going to let you sit there in the clerk's office, and each side can file their motions, and then we'll start the hearing. But that actually makes things a little more clear if there was a motion. I'm going to bring up the case for you right now. All right, bringing it up on the docket. I got to load through hundreds and hundreds of pages of items on the docket. You want to see what this docket looks like? Give me 1 second. Pardon me. All right, let's bring that over there. Let's go over here. What does that look like? Are we zoomed in? That does not look good. Doesn't matter. I'm just going to show you how many items are on this goddamn docket. Hold on. I know we're all waiting to see what it says. All right, we got to do that though, because then we can at least see what we're looking at. All right, real-time video producing, folks. All right, look at all this stuff. This is all one case. So we do that. We get to the bottom. We click on number 2. And then we wait, and we wait, and we wait. And then it loads up, and we have defendant's motion to add Victoria B. George as additional legal counsel for Pro Hoc Vice attorneys with exhibits. What? Oh, no. Okay, so I think what that means is David Dinetti and Victoria George will be the sponsoring attorneys for Pro Hoc Vice. I'm not 100% sure. We got to read the docket, but that's what I think it is. Hold on. Let me see if I can find the actual document as I eat my Cheez-Its. Towels love Cheez-Its. And 7-Eleven pizza. 7-Eleven hasn't offered to sponsor me yet, though. If they do, I'll let you all know. Maybe they'll give us coupons for 75-cent pizza instead of $1.50 pizza. All right, Dee Dee, what do you got for me document-wise? Oh, here we go. I got it. Yeah, that's all it was. I got the document, folks. Thank you, Dee Dee. Dee Dee is a wonderful, wonderful resource. Even though we don't agree on Karen Reed's guilt, just absolutely wonderful resource for getting documents from the docket. And Towel believes that even if you disagree with someone and they provide wonderful documents, they should be part of Team Docket Rocket Stars, which is Dag Nabbit, Towel, Dee Dee, and Christina Rex Bats Cleanup. And it says, Victoria B. George of the Unetti Criminal Defense Firm just moves to be added as local counsel for Pro Hoc Vice attorneys Jackson Little and Robert Alessi, who are already in as Pro Hoc Vice. Now, this could be something else. Like, I wonder if they're worried about David Unetti not being in good standing with the bar. Let's see. Why do you need to be added for this? Oh, it's because she's going to become co-counsel. Yeah, it's just, I don't know if it's just pro forma or if Unetti can't make a day of court. There could be more to it, all right, folks? There could be more to it, but not based on what I'm seeing there. It looks mostly pro forma. And by the way, if you're wondering, the fan is still going. It is not just you. It is not just me. This motion hearing was supposed to start at 10 a.m. It has not yet started. If you're waiting for it to start, which I am as well, you are going to be the first people to hear it start because we're not watching this fan and suffering like everyone else. We are going to listen for Judge Cannoni to start talking, and then immediately I'm going to show on the stream that instead of the fan. Thank you very much, Chastity, by the way, for alerting us to the new motion for Pro Hoc Vice on the docket. Yasmin UTG says, Karen is looking more and more grim as each day goes by. However, her heels are rising higher. More power to her. You know, Two hats diabolical. KR being in the same area as Officer John O'Keefe's body at the 5-hour mark, then running back to John's house and then collapsing to set up her own cover. Sick. Yeah, I think Karen deleted 17 of the 18 Ring videos between 12:37 and 5:07 a.m. on John O'Keefe's system as part of her cover-up. And remember, the keeper of records for Ring is on the witness list this time, unlike last time. Alan Jackson is staring off into the abyss. Things that thinks they are cooked, and she needs to shut up. Yeah, you're probably right. Justice for John O'Keefe, says Yasmin UTG. I agree. Watching her saying "come at me" is interesting. It is Eva. No one can shut her up, says Lisa Cox. Yep. If the fan had a spider clinging on for dear life, it would make it a little interesting. All it really does is make me dizzy. Like, I think it's actually like a disability issue, because you're making it so that anyone who has like nausea issues or whatever is just going to get sick. So I don't know why they play that fucking fan. Sorry, Towel needs his Cheez-Its. These reporters give warm tongue vibes. That's a great reference. They are very obsequious. I don't think they're like Worm Tongue. I don't think they're part of some Voldemort order. No. I said Voldemort's name. He's going to come get us. Somebody cast a Patronus. Why hasn't Judge Cannoni ruled on the motion for consciousness of guilt? It hasn't been made yet. You have to make a motion for consciousness of guilt. Last time it wasn't made till the very end of trial. It's a jury instruction. So you can make it any time. Grant, get some real breakfast, please. Yeah, I should. But no, we're forsaking Towel today. If you want to donate, I'm doing on my own accord, because I want to, a special Towel drive. And up in the comments, the posted comment, you can find the link for Lindsay Gattani's Give, Send, Go. Please support that. If you like Towel, if you appreciate this stream, Towel is asking you to do that today. Towel will eat his Cheez-Its and ramen. I don't need anything else. You go help Lindsay. You don't know how much that will mean to Towel. Let's actually see if anyone has helped Lindsay, and then I will say thank you to you, because you are a wonderful ally of Towels and the vulnerable alike. Come on, you all. Oh, you all are so good. I hope you'll all consider continuing to donate to that fundraiser, and I'm just going to add it to the description. Someone mentioned that up above, so hold on. That's not what I wanted. Sorry about that. Just grabbing the fundraiser link to put it in the actual YouTube description, where it's a little easier to get. So that is in there now. And if you, as I said, I don't want your donations today. If you send me them, I'll send them to Lindsay. Please consider donating to Lindsay Gattani's Give, Send, Go, which is located in the Towel channel description. And you're not missing anything, by the way. We don't know why court isn't in session. We're just going to keep waiting around. I can check on some of the feeds. But we are going to watch this motion hearing as soon as it comes into session. And I'm a Towel, and I'm thrilled to have you with me, and I have so much love and respect for you all for your engaged participation in the public sphere. And I'm also thrilled that I can help you avoid having to stare at a towel while getting a fan while getting dizzy. But yes, I was able to get that link up, and I'm just looking on my own YouTube feed now to make sure it loaded. So yep, that link for Lindsay's fundraiser is oh, by the way, look at this interesting video, because Sue O'Connell wants to talk about it. Isn't this an interesting video of Sue O'Connell and Karen Reed's parents? Give me 1 second. Maybe it's just me who finds this video interesting, but I don't know. You know, I just have questions about whether Sue O'Connell knew Kathleen Hawley in Canton, or whether Sue knew Rita Lombardi. Sue's a commentator for NBC10, and really, you know, what really made me read some questions, and I didn't want to give her any play. She was like, he didn't tag me, and I was like, I don't want anyone to go to your Twitter. Like, if you're really, like, biased, why would I ever want anyone to support you? You work for a legacy media apparatus. I'm not giving you play. I want to see your quarter hours, Sue. then we can talk about whether or not I'll give you play on my feed. I control that. That it was done on purpose to not direct people to your profile. There's Bill Reed, there's Karen Baum, and there is Sue O'Connell. I'm gonna buffer up here in a second. Twitter has this new thing doing now where videos buffer midway. I have to like make them rebuffer to get the HQ. But there you go. Shake your hand, be friendly. Sue was displeased. I'm a towel. People like towels giggles. Let's see. Hitting the road and listening in. Grant, thank you so much for your stellar coverage. We appreciate you. I appreciate you, Macy. As soon as the hearing is live, you'll hear it over your speakers. I'm going to assume the new attorney is no, I don't. No, the new attorney Victoria George is a white female. I don't know why you assume that. There was a law student, I think, who might have been a black woman, but I don't know. Grant, we love you, says Lisa Cox. Oh, thank you. Diana Natali says that was priceless. Can you talk about the 911 call? There's nothing odd about it. You want to know, I do think a little what's odd about the 911 call is that Aidan Kearney had that 911 call leaked to him, I think, by the Karen Reed defense, and then Aidan Kearney traded it for sexual pictures. Why? I don't know. But that's just one of the weird things that happened. Yeah, so good to if you are an ally of Jew Drops and others, you're welcome here, and I like your questions. Siggirl22. Yeah, Siggirl22. Sorry, I thought you were. It was like Sigiri earlier, but it's Siggirl22. Diana Natali says, "Come at me, really, Karen?" Her arrogance and disrespect is going to get. Oh goodness, I'm not reading that. But you are entitled to your opinion, and I'm a towel. Okay, so what are we waiting for here? What are we waiting for? Oh, I know what we're waiting for. For there not to be a fan on the godforsaken screen so we all don't get dizzy and collapse. Piore incantatum for Tom Riddle. Yes, please, yes, whatever spells we have to cast, protect Towel, protect Little Towel. Don't allow Little Towel to fall victim to the dangerous spells cast by Karen Reed. Please stop filming this fan. Every time I look over to get a status report, I just see the fan, and my mind just loses it and become dizzy. Maybe they find... Nope, they're still filming the fan. Can you all please just stop? What is actually going on? Why can't we just watch what's going on? All right, I'm going to get that fan off the screen. I'm not going to play this video, but let's pause it right on the best part. Now, what I will do is I'm going to check around on my TikTok feeds and see if I can get any information from you about why the 10 a.m. hearing is not starting at 10 a.m. How about Christina? I'm in the courtroom for a final motions hearing before opening statements. Oh, the hearing is running late and will start at 10:30. Thank you, Christina Rex. You're an honorary towel. Towels appreciate Christina Rex's. So, folks, we're 4 minutes away. You've made it. You stayed for. You're valiant. The hearing is starting in just 4 minutes. So get your snacks if you eat snacks while watching motion hearings, which is a little weird, but Towel has Cheez-Its. And then also, as I mentioned, Towel is doing a special. Don't donate to Towel today, please, if you support this stream in our last minutes. If you liked what you heard, if you appreciate this, I love you all and appreciate you, Towel friends, but please donate to Lindsay's Give, Send, Go. If even like 5 of you donate, 1 of you, it would like move mountains for Towel, and it would make me such a humble and appreciative Towel. You would bring me to tears. So if you want to do that, the link is in the description. Then it's also up pinned at the top, and the link is Give, Send, Go / all uppercase GEFJ4. Okay. Now, anyone who is so kind to do that it will mean so much to Towel, and I really appreciate it. And I'm sorry I can't read your comments out in real time. It's a lot of links to keep track of, but please visit the link. I'm going to actually post it again now. Please consider visiting the link. I'm asking you not to support Towel today, but instead to use the opportunity to show acts of service and goodness and to help people who really, really need it. And Lindsay is deserving of your support and compassion. And I really hope you will consider visiting the link. If you've ever thought, the next time Grant gives me an opportunity to pay forward what I've learned here or do an act of service, if you've ever thought about that at all, this is what I'm asking. I don't even ask you for things. In fact, I'm very hesitant to do that. I'm actually asking you, if you've been waiting for that opportunity, to pay forward that knowledge, if you have the ability, by helping Lindsay. So please do that for me if you would be so kind. Eva says, will they allow Hank Brennan to show video clips of all her interviews from the beginning? Sure, but he won't do that. You don't want to, you want to present it to the jury. You don't want to, they can watch all the evidence in the jury room. When you're playing it, you want to make a point. You have to have a theory. Let's see, Angela Whittick. Single white female looking for a man like you has an eeriness to it in light of this case. Yeah, that's true. Dewdrop says it is a very annoying element of this case. It is. We're 2 minutes away, folks, by the way. Hearing starting at 10:30 per venerated reporter and honorary towel and member of Team Docket Rocket Stars, Christina Rex. Towel is going to be with you all. Hopefully this hearing doesn't take too long because I have a final to work on, but I'm going to sit here with you. We're going to watch. We're going to see what happens. We're going to watch it in full together, and hopefully the fan goes away in the next, minute, because I was losing my mind watching that godforsaken fan. Let's see. Is the fan gone? I'm sorry to report the fan is not gone. That is terrible news. Just absolutely terrible news. Hold on. I'm skipping forward. Nope, the fan is not gone. Please, for the love of God, just bring us salvation from this fan. Do not make us watch the fan. All right, what else do we got? Wait. No, I don't think... I think Dewdrops was agreeing with you, Angela Whittick. I think Dewdrops was saying that behavior by Karen is annoying. And I agree. I think you made a great point, Angela Whittick. But yes, if you're just tuning in, the 10 a.m. Karen Reed hearing got delayed. It's starting at 10:30, which means right about now. Now, can I make the hearing come into session at 10:30? No, I cannot. But I absolutely am here with you. And as soon as you hear a little sound, just a little sound, come over your screen, that is a sign that we are in session, folks. And Little Towel has the volume up. Little Towel has the closed captions ready. Little Towel has everything set up for us. The only thing we're not going to do is watch the fan. I won't do it. I won't subject you to it. I won't subject me to it. But also, it is weird. These streams are so dynamic. It's not like anyone knew the hearing wasn't going to start at 10. You tune in, it says 10 a.m., it gets noticed for 10 a.m., and then all of a sudden it starts at 10:30. Oh, I'm sorry. I absolutely need some liquid after that drink, after that extended soliloquy. And my prime drink today is rainbow sherbet. It's actually quite good. Maybe I'll send Prime an email and be like, want me to talk about Prime on the stream? I'm going to say I like it anyway, but actually one time one of the court officers was like, Graham, would you, the reason you all can't have labels up on the, sort of the table sill when the hearing's going is because people could be getting paid for, advertising. And I was like, Chief, I wouldn't let them pay me if they offered me. And then I realized, wait, well, maybe if 7-Eleven offered me, I would do a pizza advertisement. Dewdrops, the internet is delayed. Oh, don't worry about that. Yeah, see, I think sometimes people are seeing different parts of the stream when they're commenting. So anyway, you are all towel friends and you are cordial with each other, and it's very easy to discuss and stay cordial if there's any misunderstandings. And now I am, of course, on Christina Rex's Twitter feed, keeping an eye to find out if this 10:30 a.m. hearing is actually starting. No, nothing now. So it looks like we're all just waiting together to no longer have to be made dizzy by that fan. And I will admit, normally I don't get dizzy, other than when I'm a passenger in a car or something, but watching that fan, it actually makes me quite dizzy. All right, so we're waiting for the motion hearing to start. I think every single channel is showing this fan. I don't know why they all want to show this fan. I don't know why they can't show the ceiling. I guess it's the pool operator, but all right, I'm going to take one more look. No, it is still the fan. Actually, I found a way to look at just what's above the fan so I can tell when it moves, but I refuse to look at that fan. I refuse to subject you all to it. Oh, Dewdrop says, no way, I love you. Oh, you guys are so kind to each other. I'm glad you're all able to talk it out. And we're not gratuitously waiting, by the way. It's just we've gone over all the motions. This hearing was supposed to start at 10 a.m. It got delayed. And no channel has coverage because it hasn't started yet. But as soon as the hearing does start, you all will be the first to know. And we will watch it unfold. I mean, what's so interesting is even though that Pro Hoc Vice motion went up, that's not really what we're dealing with today. We're dealing with all the outstanding motions. There's only a few. Aidan Kearney testifying being the big one. The introduction of Karen Reed's statements, which isn't really a motion. It's more of notice from the state, because you can always use the defendant's statements against them. That's just fundamental under the hearsay rules. But yeah, we're going to see some arguments today. So anticipate potentially some oral arguments. If Bob Alessi gets up, we could be here till 4:30. Lisa Cox says, guys, we have the best group chat. I agree. It's a nice way to watch a hearing. Even if we can't control when the hearing starts, it's a nice way to chat together as we wait. And you can't control the court process. Lisa Cox says, Cookie Ramlaw, we are. And Yasmin UTG says, God, I just want Karen to be in prison. Is that too much to ask? Lisa Cox says, I feel the same way. Angela Wittick says, never worry. Towels have it covered. No, I appreciate you all. Dewdrop says, Lisa Cox, we sure are the best. And Yasmin UTG says, hey, Lisa. Well, one thing I've done today is I've kept up with all these wonderful comments. We've done a wonderful donation drive. We've got a chance to ask people to reach out and support the vulnerable. There's nothing more noble than supporting the voiceless and the vulnerable, and that's Towel's big theme of today's stream. Nonetheless, I cannot force this God-forsaken trial to come into session. Fan, it still spins endlessly on and on and on and on. But we Towel friends, we stand together, and we wait, and we wait. And as we wait together, we have a pretty good sense of what the hearing is going to be about. I just don't get it. Why can't we just start the hearing? I don't understand why it has to be this convoluted process. They're all already in the building. They all filed their motions. Is there something else that has gone up on the docket? There has not. Actually, you know what? We can check the docket one more time. Why not? Bring the docket up here. Sometimes the case docket reloads if you don't keep the tab open, but we'll see. We are going to see. I don't think anything new would have gone up on the docket, but if something new went up on the docket, that would explain what the lawyers are doing, because that would mean they're down in the clerk's office filing things. Anything new? Nothing new since we last checked. Nothing new. This, of course, I think is going to be one of the big motions that comes up. Aidan Kearney asserting the fifth. But how would we know? Because the court is not in session. A 10 a.m. hearing. We're going past 10:35 now. They're not in session. And I think Angela Wittick reflects a lot of the sentiments of so many folks, which is, hang on, O'Keefe family and friends. Justice may be slow, but it's coming. Dewdrop says, justice for John O'Keefe and his family. Dixie Doodle says, I'm so ready for the trial to get started. TurtleBoy was notified he has to come to court now over his sequestration. Oh, Melanie, thank you so much. Being chance the hearing is being delayed, we think it might have to do with TurtleBoy coming to court. Maybe Karen is considering a plea, one can hope. Dewdrop says, Angela, yes, 100%. Yasmin says, Dixie Doodle, same. So Melanie, I think, is our, I've never met Melanie, but we're thrilled to have you, Melanie. It seems Melanie is our social media sleuth. Do we have an update from Aidan TurtleBoy Kearney as to him being summoned? Ordered into court? If you have an update on that, he said he will get there at 11:15. Oh, so are we now holding? Why can't we do the other motions then? We have to delay everyone for Aidan Kearney? Really? Really? Why can't they argue like the Gretchen motion or whatever? Oh, come on. Well, no, it's not that he's late, Yasmin. It's that he probably didn't get notice till this morning. So your obligation to show up only starts when you get told you have to be there. So yes, it's actually okay if they say to you, you must be here for a hearing today, and you say, okay, I'm leaving my house now, I'll be there in an hour and 15 minutes. That is okay. Yeah, so that's what I'm saying. He said he was called at 9:45. If you got a call and you're not at the court, he wasn't covering the case today. If you get a call and you're told you have to be at court, you can absolutely say, okay, physically, I am this far from the court. And no one's going to hold it against you because it's really a notice thing. You only are obligated to show up when they tell you you have to show up. And if they never told him until the last minute, they can delay. But mind you, folks, if he's coming into court, it's going to be the Lumen Martin hearing. Yes, it's going to be the Lumen Martin hearing. Oh, my God. I knew it. I knew it. They're going to close the courtroom. They're going to close the courtroom for his, they're going to close the courtroom for his Lumen Martin hearing. This is going to be big. I hope you all are ready. We are going to see some shit today. Wowza. Get ready for the fireworks. This could all happen very fast. Yeah, let's go into a Lumen Martin hearing. Hold on, I'll get an overview for you. Give me 1 second. 1 second. The best way for me to do it is to just have it summarized because it's complex case law, but give me 1 second. Towel's going. We're going to talk about what I think is about to happen with this breaking news of Aidan Kearney being ordered into court. All right. Here's the answer. I had to type that out. Sorry for that. So a Lumen Martin hearing is what I think we're about to see happen, and I'm going to get an overview for it right now. And it's easier for me, as I said, to I'll bring up the case if we have to, but I think it's actually 2 cases, so I want to find out their exact citations. While we're doing that, I will go back to the chat. Yep, there are a lot of questions. Somebody, no problem with asking questions, Yasmin. That's going to actually give us a chance to look into what a Lumen Martin hearing is, and I have that answer for you right now. Come on. It's actually more than just getting the answer. I have to pull up 2 separate case files, and then I have to plug them into this thing, and then I have to get their citations. But we're doing it. And it is important because of Aidan Kearney. And obviously, if you're just tuning in, the 10 a.m. Karen Reed hearing has been delayed. We're waiting to find out if they're going to handle other motions or if they're just going to wait for Aidan Kearney's arrival at 11:15 because he is a witness and is apparently trying to get out of a subpoena. So we are going to wait together, and I'm going to explain a little bit about what a Lumen Martin hearing is in Massachusetts. Don't really understand why I have to wait this long, but okay. Here we go. It comes from Martin v. Commonwealth, and it has to do with Lumen Martin. His full name was Lumen Martin. And it's Commonwealth v. Martin, 423 Mass. 496. There was once a time in Massachusetts when a witness who had already testified before a grand jury could simply invoke his privilege against self-incrimination and avoid having to testify in court. Then, in the mid-1990s, when street gang violence was perhaps at its worst in Boston, things started to change. Oh, this is very interesting. Prosecutors started to fight the trend of violent gang members who witnessed crimes refusing to testify. One way of doing this was to put the witness in the grand jury and lock him into his testimony. Many of these witnesses agreed to testify at this closed proceeding under the erroneous belief that they would never have to testify against the defendant in open court. This is from the law office of Stephen Nyman. I was often told that police officers and unscrupulous DAs would create the false sense of security. Then, when called to trial, the witnesses would either feign memory loss or refuse to testify. This tactic was challenged in 1996 in the case of Commonwealth v. Martin. Luman Martin was charged with several violent Massachusetts felonies. One witness testified against him before the grand jury. The witness was also the primary victim in the case. He testified that Martin put a gun to his head and threatened him. At that time, another party came to the witness's aid. Martin then fired at the parties, missing everyone. The witness knew Martin as the two had grown up together in the projects. At trial, the witness told the judge that he needed to talk to his lawyer. One was appointed for him. The lawyer told the judge that the witness had a Fifth Amendment privilege due to the fact that he had lied before the grand jury. The judge did not believe the witness, and the issue was reported to the SJC. The issue on appeal were, 1, can the witness invoke his Fifth Amendment privilege if it is determined that he has lied before a grand jury, and then 2, has a judge made that determination. Now, we're going to look at the bigger picture here, because that is, in fact, specific to our case. We're looking at the bigger picture. The law when someone claims a privilege against self-incrimination after having testified by a grand jury. Oh, but we're not talking about that. If you lie, that a judge can make the decision as to whether or not the invocation of the privilege against self-incrimination at trial after testifying before a grand jury is valid. A judge does not have to accept the representation of the witness's lawyer or the witnesses. Rather, a judge can so this is what we're talking about. A judge can conduct an in-camera hearing to determine whether or not the privilege exists. The in-camera hearing is limited in its scope and is recorded for appellate challenges where appropriate. That's what I think we're going to see today. So, let's see. It's actually a Luman Martin hearing. Now, the reason this is relevant is I don't know how this is all going to play out. I've seen this happen before, but the courtroom gets closed. So I don't know what we're about to see, but I'll tell you, it hasn't started yet because all we're seeing right now is a fan. And apparently we might actually have to be delayed in this Karen retrial hearing because of Aidan Kearney. This is ridiculous. Making us late. I'm glad to make you happy, Drew Drops. We need it in times like these, says Angela Wittick. That's great. Yasmin says, okay, I need a summary. Well, I'll try to give you a summary right now, Yasmin, actually, so give me 1 second. Basically what it means is that Judge Cannone is going to close the courtroom and then interrogate Aidan. That's what and if it's an order for Aidan to show up, that means Judge Cannone probably ordered it. Let's read TurtleBoy's post. Maybe that will give us some insight. Not making any promises about this. This could be a big one, though, folks. This could be a big one. All right. Let's see. What do we got here? Let's see. Is that up on your screen? No, but I can see it. Okay. After 2 weeks of bugging and asking him, this is what Aidan said. Clerk Jim McDermott alerted my attorney via email at 9:45 that he needs me there by 11 to hear our motion to exempt me from the sequestration order. I live an hour away, so I had to get ready and just left. I should be there by 11:15. So, seems like we're now hearing that 11 a.m. is going to be the start of the hearing. 11 a.m. This is big. This is big, folks. This is big. I'm going to tell Christina. All right. I've just reported it to Christina on her Twitter. She still doesn't know why it hasn't started. There's a lot of people, I think, who are just like, what's going on? So thank you to the wonderful friend in the chat who alerted us all to that. What I'm going to do right now is I'm going to actually retweet cast, and I'm going to let folks know that this is going on. So 1 second. How do I... Oh, I have to actually go into the producer to do it? That is incredibly annoying. Why can't I just chat it from within this window? Or post it from within the window. All right, hold on one second. I think I can do it this way. New Karen Reed trial final motion hearing delayed until 11 a.m. Aidan TurtleBoy Kearney ordered into court over Fifth Amendment claims in attempt to avoid being sequestered for the entire trial. Coverage live now. Okay, sorry about that. I had to put the phone down. Sequester. I had to put the mic down. New Karen Reed trial final motion hearing delayed until 11 a.m. or 11:15 a.m. And I should put Eastern for the towel friends who are not in America. Aidan TurtleBoy Kearney ordered into court over Fifth Amendment claims in an attempt to avoid being sequestered for the entire trial. Coverage live now. I'm a towel. Wow, that was intense, huh, friends? That all developed very fast. Even Christina Rex, I don't think, knew why it was delayed, and she's in the courtroom. Ed Jobs, great to see you. It was that was submitted this morning. The motion for Victoria George being added as extra local counsel for pro hoc vice status for Alan Jackson, Elizabeth Little, and Bob Alessi. Do you have any theories as to why that might have happened? Victoria George is indeed a member of Yannetti's law firm, so say Yannetti's not there one day, she could be a sponsoring attorney. Maybe they foresee issues with Yannetti's good standing with the bar coming up mid-trial. Melanie says she thinks Aidan knew he had to be there and he wants to fuss. I'm not sure about that because I didn't see anything about it yesterday, but he should have known. He really should have known. Let's see. What other questions do we got? Karen, I'm marshmallowing all resources. Ed Job says, why so random? Well, I wouldn't say it's random. I wouldn't say it's random that she submitted that. It is a little bit interesting that she submitted it. But, she works for Yannetti's law firm, the lawyer, so why not add her as a sponsor? And also, please do consider, Towel has been saying, please don't donate to Towel today. If you send Towel donations today, I want to let you know, every single thing you send to me, I have not looked at my phone yet, I am going to send to Lindsay Gattani. So if you want to send donations, that's fine, but I'm going to send them to Lindsay Gattani's fundraiser, and I will document every one of them, and I will send them along to her. And I will also say thank you to you in real time. So that is your donation reminder, and I'm going to be gratuitous today because it's not me that I'm asking for help for, and I won't actually take any of this money. It is someone else. And if you've ever felt comfortable supporting Little Towel and you want to take Towel's call to try to make the world a better place and act on it, then Little Towel is giving you a way to do that today, and Towel will say thank you to every single person. Okay, so we just got, was this the document that already went up related to Victoria George? Yeah, I think it is. We just got a docket entry from the court, but it's I'm 90% sure it's just the Victoria George motion, which we already had and read on this stream. Yeah, that's all it is. All right, so now, folks, we are all sitting around, sitting together, and we are waiting for what could be an 11 a.m. start of the Karen Reed motion trial hearing today. Towel is also reminding you about the importance of supporting the vulnerable, and I included a nice link that you can use for a Give, Send, Go campaign, and that would make Towel pleased. Yes, it looks like we're getting up at 11 a.m. Court is about to start. I have the fan ready. Here we go. All right, friends, hold on one second. The lawyers are just introducing themselves. Towel is going to unmute this now. Hold on one second. Oh, it is unmuted. We don't have audio yet, friends. Hold on. Hold on. Towel, unfortunately, cannot control the pool feed. Hold on. All right. Where is the audio? Where is the audio line, crime? Come on. They should know that they're... How do they not know their feed doesn't have audio? Don't worry. You're not going to miss anything. Is this really possible? How is this possible? I almost refuse to believe that they don't have working audio on the Law and Crime feed. Give me 1 second. No, it's entirely possible that just that one channel doesn't have working audio. But the lawyers are standing up now, and we're going to listen to this. But I'm just utterly baffled. How can you be in the courtroom? How can you have everything set up, and then as the hearing starts, the main feed through Law and Crime doesn't have audio on the camera feed? No way is it still not up. All right, hold on 1 second, folks. This is actually astounding that one of the primary feeds for the trial does not have, and I know it doesn't have audio coming through because it doesn't have closed captions, even though closed captions are enabled. It was just sitting there, playing nothing. All right, I got the motion hearing from the pool feed. Finally, let's see if this audio works. It's not you all, folks, by the way.
That damage has been done. It can't be rectified.
Hold on 1 second.
But
so, folks, if you're trying to find this hearing, some of the channels are not broadcasting it right. There's a problem with the audio. I have found a copy of the stream that does have the correct audio, so bear with me for 2 seconds. It is not you. One of the most frustrating things about this trial is that the way the feed is distributed to each channel is not audio specific. They all do their own audio. All right, here we go. This is starting to become infuriating. I had that whole Law and Crime stream up ready, and they just totally messed up the audio. That's all right. I'm going to bring this up for you now. I'm going to try to save you from the court fan, and then as soon as the hearing starts, I'm going to relax. So give me 1 second. It is not us. I refuse to blame any of us for this ridiculous situation. Come on. Why is this doing this? Why must you torment me right now? I don't understand. Little Towel did nothing to deserve this. All right, we're going to the backup plan. That is not the backup plan. Here we go. We got it. Thank you for your patience.
Detective file of the Canton Police Department.
So we're just hearing the first motion, folks. You didn't miss very much. Here we go. 5 minutes.
Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Judge 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists
on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information, and so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Bryan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing, it's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been denied our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Bryan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case, and it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case, but they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. So the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view. She can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to
So why don't I see counsel at Sidebar about this anyway?
So here's the one interesting part of the fact that we're a few minutes behind. We'll take a look at the zoom in on Karen's parents and the people next to her. Someone's asking who's behind them. That's Karen. That's Aidan's girlfriend, Meredith O'Neill, and that's Esty behind Karen's mom. And yeah, nothing. I mean, obviously, I think Meredith and Esty have said things I've disagreed with in the past. I've probably said things they've disagreed with, but I have no personal animosity towards either Meredith or Esty, and I don't say mean things about them. And Meredith actually posted a nice photo this morning with no negative comments of me, TurtleBoy, and her standing in front of a court. I'm taking a picture of Aidan. Meredith is smiling behind Aidan, and Aidan's taking a picture of me, and then someone's taking a picture of us. It's very metaphysical. I don't know. Meredith sent me a donation one time on this stream. I think she thought she had to send a donation to ask a question, which is why up above my head it now says you do not need to send a donation to ask a question. She's all right. I don't know. As long as she's nice to other people, I have no problem with Meredith. Same thing with Esty. Esty's never been mean to me. She might say things about my views and whatnot, but she's never been mean to me. There's our silent close-up while the court's at Sidebar of Bill Reed. I don't think we really need to watch Bill Reed for this long, but why the hell not? What are folks saying about Bill Reed? He does look a little bit like Mr. Burns. Someone says, Bill Reed is complicit in the cover-up. Karen went up to Sidebar. Yeah, that is kind of rare. First glimpse, well, it's because it's about Karen going on The View, so. First glimpse of Welcher's report, and it was a map. They got GPS from her car. What first glimpse? Where? Murder by Maestro. Where do we get that? You must clarify for Little Towel. Where did you see the glimpse of Welcher's report? Was it on the stream? I'm waiting for Murder by Maestro to hear this, and then Murder by Maestro's got to type in the comment. Did I miss it? Where was it? Murder by Maestro. Where was it? Let's see. Was it back a little bit or something? Where do we see the glimpse of Welcher's report? Did you see it on the table or something?
other investigations. They can go to the detective file and they can.
Hold on. Are you seeing it right there, Murder by Maestro, on the table? It's going to come up on your screen in a second here. Is that what you're seeing, my friend? I'm going to try to zoom in on it for you. Actually, I think what we're going to do is duplicate this window so I can zoom in even closer. Murder by Maestro, are you talking about that document right there? Are you talking about that? Are you talking about something else? Hold on, I'm going to wait for Murder by Maestro to tell us. 1 second. What do you got for me, Murder by Maestro? What did I see? I'm watching hopping between her and... Oh, yes, but where can I see this first glimpse of the report? Where did you see it, Murder by Maestro? Was it on the stream? I don't see it there. Was it somewhere where when they had viewed the defense table? That doesn't really look like a map, does it?
What we're going to do is...
So this must be what you're talking about,
just
right?
the motion for the view.
Hold on, and that's all we... No, they come back to the defense table. Hold on. It's not there, right, Murder by Maestro? So were you thinking about maybe it's closer to here? That's not a map, though. You can't say that that's a map, can you? Is that what you're talking about? Because I know you're probably analyzing something you saw on the stream, right? I'm still waiting for Murder by Maestro's follow-up, but that doesn't really look like a map to me. Maybe it was earlier. Hold on 1 sec. What are we thinking about here, Murder by Maestro? Where are you seeing this?
Morning, Your Honor. David Unetti.
Map. Not seeing it there. They didn't mention a map.
Mr. Brennan and I spoke about it. We had...
Oh, hold on. Maybe it's after the sidebar. Murder by Maestro, are you 5 minutes ahead in trolling Little Towel? All right, here we go.
This list, I don't understand. All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list? All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank you.
Thank you, Your Honor.
Okay. So...
It was a map. Oh, my word, Murder by Maestro. Hank Brennan's expert has a map from Dr. Welcher, which is going to show location data of Karen Reed's car. We knew it. We knew it was coming. This is the new information from the chip-off. Everything is crescendo to this moment, and it really was that data, the piece of paper that I zoomed in on earlier. Murder by Maestro. Again, my friend, nailed it on the money. God bless you. Much love to you, sir. Let's continue watching the hearing. I just clipped this. I'm going to post it now.
Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. so that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will they rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, etc. But otherwise, it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right. Okay. That has. I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it, for several years he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition, and the whole topic of pattern recognition was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans, and we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. we want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say I am not going to get into the basis for that. I just wanted to, because...
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration.
Of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Lewis.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's question, comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed?
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio-visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going
Your
on?
Honor, we're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to the defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for...
I think that's what they just said they're just going to give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion? I'll bring you all back tomorrow. I don't really want to. That's sort of you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, he's a state trooper, he found the text messages, he was the one who downloaded the data, he was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction. And completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say, as a preface, that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5? Oh, yes. With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses. All right. The ARCA witnesses. Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted Docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, Docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with Docket 642, which was a response to Docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but...
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all of the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr. Jackson.
The number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, etc. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, etc., we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinschler talked about what he did, which was more on the biological side.
There was a difference between the two.
And Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it, and it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that is on. That's
can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential.
Right.
And
can I see Counsel Sidebar, please? All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did you
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, etc. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect, in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, the fact that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern, and that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery.
You should switch to 1-800-CONTACTS because it's
super easy, so cheap. I save shipping costs.
I made representations to this court, not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionists they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
Your Honor, what appears to be feigned indignation is just not
information that we...
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided his CV in November, and then we provided on our discovery deadlines January 31st, 2025, and then on February 5th, we provided all of the detailed background notes, references, and so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible, so we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to...
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but...
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of...
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
All right, folks, you heard it. We are in a 15-minute recess. My word, it is just it is rapid fire today, folks. It is rapid fire. No, I am not going to make you watch the fan. Please do not film the fan. You hate us, Court TV. You just hate us all. So what I'm going to do is, so we don't have to watch this fan, I'm going to take the fan off the screen. And I'm going to put some motion on the screen. And then I'm going to play this. And in 15 minutes, so that will be about 12:30, we will come back. We'll hear the end of the arguments on this motion related to the internal affairs investigation. Judge Cannoni said we're probably not going to get a ruling till tomorrow, so no ruling's going to come down. And then they're going to argue the big motion related to Aidan Kearney, which is on your screen right now. Aidan Kearney asserting the Fifth Amendment and trying to get off the sequester list. There was a lot that just happened rapid fire. We didn't get any rulings. It all happened very, 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 very quickly. And so what I want to do is I'm just getting up the update about ARCA, getting that out to I simultaneously broadcast this, clip this, write it up, and then promulgate the clips. And it frustrates me because I wish it was all instantaneous, but I have to sit here and I have to wait for these video files to upload. And sometimes they're like 10 minutes long, and that is the most infuriating part of this whole process. All right, so that's uploaded. Now I need you to bear with me because I need to type one more thing out, which is, and I will actually read it to you as I type it so that at least you can hear what it is that I'm sharing. And with that, we are in a 15-minute recess for today's final Karen Reed and John O'Keefe motion hearing before retrial begins on next Tuesday. After the break, there are 2 motions to be argued, including Aidan TurtleBoy Kearney's attempt to invoke the 5th and avoid sequester. Okay, is that exactly what I want? That's exactly what I want. I hope I spelled invoke right. I did not. Okay, thank you for your patience. Little Towel had to get up a piece of information just to get us to recess. So I managed to stay relatively updated. We didn't really get rulings. We got some previews. We got some hints as to what's coming. But other than that, we just went into recess. Now, what I would like to do is read some of your comments. That was going very rapid fire. And then I would like to, I do my best to keep up with everything in real time, but it can get extremely intense because you have to segment out the clips into each development. But I'm going to look at some of the comments here. What do we got going on? A lot of you hanging around watching with Little Towel. I do think Hank Brennan was making some excellent points. AJ is so off his game because Judge Cannoni is onto him with ARCA. I agree. Lynn Harris says, Grant, how did they ever plan to start trial today? Yeah, well, these rulings were all going to come hard and fast. Reminder, we have been through 50 or so motions in limine, and these are the only 6 left. So the Judge Cannoni can do this in 2 or 3 days. She could have done it in 24 hours if she needed to. B and Chance says, Hank Brennan was coming in hot. Yes, he was. Yes, he was. Bill reads says Ed Jobs. Bill reads like they're on to us. Ed Jobs says, Karen's brother's face is so snobby. Well, he's on the witness list. Lynn Hennis says, preach it, Hank Brennan. Judrop says, come on, Judge Cannoni, the defense is wrong here. Ed Jobs says, Hank Brennan articulates it all perfectly. Judrop says, justice for John O'Keefe and his family. B and Chance says, fiend indignation. Foolish, Alan Jackson. Judrop says, sit down, AJ. Alex says, please, Judge Cannoni, don't let them cheat with ARCA again. B and Chance says, the judge knows what she ruled. Judge is on to him. Who's next to the parents? I'll check the front row. It's her tech guy and some other people. And some law school students, maybe. Judge Cannoni, says Lynn Harris, remember what you did earlier, giving AJ a break. Don't do it again. Oh, actually, we can watch that, Lynn Harris. Do you all want to see the moment where... I can find you all the moment where Judge Cannoni scolded Reed's lawyers for their material misrepresentations related to ARCA. Just give me 1 second and I'll pull that up for you. I have to, I had it up earlier, but there was so much going on, I closed a lot of tabs to give us a little bit more functionality with poor little Towel's computer. Just poor little Towel's computer trying to be a news station in and of itself, the poor little thing. Everyone, I think we should thank, all the Towel friends should thank Towel's computer for doing such a good job. Good job, Towel computer. We're all very proud of you. All right, now let's see this scolding by Judge Cannoni of the Reed defense. Where is it? I remember, I think it said breaking. Where is it? Where is it? Come on now. The finding on the record. Come on, Judge Cannoni. All right, where is it? It was the, is this it? No, it was that morning, I think. I'm going to find it. It was what I'm looking for is the clip where Judge Cannoni scolds them. And seeing Judge Cannoni just unload on Reed's defense is very cathartic. Let's see. Where's the ruling? Come on, Judge Cannoni. Does she wait till the end to make the ruling? Maybe it came at the next hearing. Hold on, I'm intent on finding this. Where is it? Where is it? Got it. Found it. I'm a towel. You're a towel. We're all towels. Let's watch this, shall we, folks? Let me make a big screen for you, and let me get the volume going. 1 second, I have the tab muted. And this is really the history of when Reed's lawyers got in trouble for hiding stuff about ARCA. So her attempting to get over this hill is just ridiculous, because this is what happened months ago on March 17th related to ARCA.
All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So, I think I told counsel before that I had reviewed, so first we had full hearing from counsel. I heard from the lawyers, I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts, I've listened to the Sidebar conference and read that transcript, and I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So, I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations, and before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Now, I want you folks to understand how serious that was. That was last month regarding ARCA. Karen Reed was already in serious trouble, and today went even worse for her. Now, let's take a look. I imagine it is the fan. It is indeed the fan. Hopefully court will be back soon. It is very annoying to watch that fan. I'm not going to make us do that. I will go back to your comments, though, and just be aware that things are looking very bad for Karen Reed. We are on a short break. Court should be returning, I would say, in the next few minutes here. Sig Girl says, Alan Jackson, I'll show you, gander and a goose. B and Chance says, Alan Jackson's lies are so transparent. Dewdrop says, Team Hank Brennan. Ed Job says, this is intentional from Alan Jackson. Delay, delay, delay. Dewdrop says, Alan Jackson's tactics make me sick. Def Otter says, Hank Brennan makes Jackson look small and meek. I agree. Alex does not like AJ's style. Brady the Goat 12, I love your username, says, gig is up, Jackson. The court doesn't trust you. Just because you said Tom Brady's the GOAT, you win. You're an honorary towel. Trevor McIntyre says, wow, she's giving the judge a deadline for a ruling. Not a good idea. Ed Job says, this is sick. Sig Girl says, Judge Canoni wants everything in writing, and that's good. I agree. Dewdrop says, go Team Hank. B and Chance says, Grant, did Giannetti leave to speak with TB? Who knows? Dewdrop says, Judge Canoni, maybe Giannetti went to go meet Lucky Lofgren in a parking lot again. Just coincidentally, the parking lot of the school where the state trooper sister works. Judge Canoni will give them what they want. Thank you, Grant Ellis, for your hard work and coverage. Anytime, Dewdrops. Court should be back in session any minute now. Sig Girl says, I had to look it up. Promulgate, verb, announce. To announce something publicly, especially a new law. Yes, that is promulgation. Grant, it's Lynn Hennis. You're doing great, Grant. Lynn, it's so great to see you. I'm sorry if I misread it earlier. The screen, the letters of people's names are very small. But yes, so good to see you. Macy says, just tuning back in. Is this from before? I felt before anything started. I left before anything started. Any bombshells? Yeah, oh, well, there was a lot of fireworks. There was a lot of issues covered in rapid succession. If you missed the first part of the hearing, we can get caught up on it pretty quickly because I just wrote them up on my Twitter. So we can just look at each video and I'll tell you what happened in the hearing. So it started a little late, and then the first ruling was mostly about CPD videos. Reed wanted like more specific to discovery through Elizabeth Little. Elizabeth Little like tried to talk to Hank Brennan instead of through the judge, and she got scolded. Then we saw this. This was an important moment. This was the video showing that it appears Hank Brennan's expert, Dr. Welcher, has time and place or location information for Karen Reed's car, and there was a new map provided. So let's take a look at that.
All right. So on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank you.
Thank you, Your Honor.
Okay. So.
It was a map. Oh, my word, Murder by Maestro. Hank Brennan's expert has a map from Dr. Welcher, which is going to show location data of Karen Reed's car. We knew it. We knew it was coming. This is the new information from the chip-off. Everything is crescendo to this moment, and it really was that data, the piece of paper that I zoomed in on earlier. Murder by Maestro. Again, my friend, nailed it on the money. God bless you. Much love. And I think I even bring up the zoomed in map. Look at that. It's a map. That's Fairview. Do you all see that? That is, I'm pretty sure that's Fairview. That's the turn. That is the area. They have her time and place information. Murder by Maestro was right. We knew it was coming, and By God, it's here. Let's find out if the court's back from recess. Hold on, my dear towel friends. We have a commercial running. It's okay, it's muted. You won't hear it anyway. Good for court TV. The court is still on recess. We are not watching The Fan. There is a towel rule against watching The Fan. It makes towel dizzy. But Murder by Maestro, my friend, you pointed that out earlier, if you're still with us, and you nailed it. Enjoy Drew Drops, your quick run out. Macy, I know we were getting you caught up, but that's the biggest news. Hank Brennan's expert, Dr. Welcher, has that map. You can see it in Bob Alessi's hand. Tal did a little good zoom in on his review earlier, but my word, that's important. And then, of course, other updates related to Karen Reed likely losing her motion related to Dr. Crosby. If you missed that, here's the quick 3-minute clip. It has to do with Karen trying to argue that Hank Brennan's dog bite expert shouldn't be able to testify to the fact that Dr. Marie Russell, Reed's dog bite expert, is wrong and that there's no dog DNA in this case. But let's take a listen to that if you missed it.
All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar, so it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Lewis.
So Hank Brennan and Bob Alessi go back and forth on that argument. It was very interesting, and we don't end up getting a ruling. If you're wondering, is the fan still all that's on the stream? Yep, we are still in recess. We're waiting to come back. Who knows if we're going to go through lunch? The Judge Canoni does not want to come back another day this week. She wants all these motions argued now. We only have 2 motions to go, including the big motion about TurtleBoy relating to him attempting to invoke the Fifth. Now, if you missed it, we can also take a look about Reed agreeing to the motion to allow her statements.
Okay, so that
made to media in for the purposes of Hank Brennan's opening. We can take a quick review of that. And if there's not going to be a lunch, we may as well get caught up on everything that happened in the morning session now. And if you're wondering, yes, I really did clip this all in real time and then get all these clips up as you all were watching the stream, because I'm a multitasking little towel.
Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. If you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
Well, we could have somebody plain clothes from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Okay, trial's coming back into session, folks. Little towels on it. Little towels on it. Look at that.
Court is back in session. You may be seated.
All right. So the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
It's
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to Sorry, you stay right there, Mr. Bradel. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right, now I'll hear you, Mr. Bradel.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on...
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first...
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client and...
Have a minute to talk to him.
Sure.
Holy shit.
Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
Oh, my word, folks. You just saw it happen live. Is Aidan Kearney about to be forced to the stand to assert his Fifth Amendment rights? We will find out next. Oh, my word. I can't believe we just saw that. I cannot believe we just saw that. I'm not going to make you look at the fan. I have to write this up. Oh, my word, folks. I hope you're on pins and needles. I hope you are on pins and needles. All right, let me write this up. I don't know. How do I even write this up? I mean, they're going to force him to do it. It is a moment for the ages. Hank Brennan, you miracle worker. You miracle worker, you. Oh, my word. Karen Reed trial prosecutor Hank Brennan is forcing Aidan TurtleBoy Kearney to take the stand at today's final motion hearing before Reed's retrial for the death of John O'Keefe begins next Tuesday. 10-minute recess before the big moment, if it happens. Is trying to force, I'm going to say trying to force, to take the stand and plead the fifth. Personally, 10-minute recess. Oh, wow. Here we go. All right, I managed to get it, folks. I managed to get it going. I don't know if I'm ready for this. I don't know if you're ready for this. It's a 10-minute recess. We need to wait until about 12:55, and we're going through lunch. This is the moment. This is the moment. Aidan Kearney is going to be turtle walked to the stand. I'm going to say turtle walk. Karen Reed, trial prosecutor Hank Brennan, is trying to turtle walk Aidan TurtleBoy Kearney to the stand to plead the fifth. Plead the fifth. To plead the fifth personally, and I have to change that to fifth. Personally, at today's final motion hearing. Oh my word, 10-minute recess. Oh wow, this is the greatest thing I've ever seen in my entire life. I can't believe we're all here for this. I can't believe all the towel friends are going to watch this happen in real time. This is the greatest thing I've ever seen in my entire life. He's going to be turtle walked to the stand and have to plead the fifth for the whole nation. I've waited my whole life to see this. I'm so thrilled that all the towel friends are here with me. We're going to watch history be made. It is going to be the greatest 30 seconds of my entire life. I've waited so long for this moment. You go up there, Aidan Kearney. You get turtle walked up there at Hank Brennan's request, and you plead the fifth. Are all the towel friends ready? I know Towel's ready. This is historical, I say. Do I need Angela Winnick? Angela, get ready for this. It's going to be the greatest 30-second moment of your life. Holy macaroni. I've never seen this in 20 years. Wow, just wow. He's going to turtle walk him to the stand. I can't believe this is actually happening. I am blown away. I'm sorry, friends. I've read so many documents. I've seen so many hearings. I've never seen anything like it in my life. This is the greatest moment of any trial I've ever seen. It's not even during the trial. It's the final pretrial motion hearing. It's the greatest thing that could possibly happen, and it's going to happen sometime in the next 5 minutes. And we're all here to see it. He's going to get turtle walked to the stand. I hope you are relishing vicariously in my joy. And we don't even have to take a lunch break. I can just sit through this and then I can go get lunch. Oh, Towel has just been blessed, friends. I really hope he does this. Do it. Make him do it. Make Aidan Kearney get on that stand and take the fifth. Every single person in the United States who's followed this trial wants to see Aidan Kearney turtle walked by Hank Brennan to the stand and forced to take the fifth. It is the dream of every red-blooded, well, blue-blooded, or red and blue-blooded American with white blood cells in there for hemoglobin as well. By God, it is the dream of every American. This is everything that I've wanted. This is justice manifest. Oh, hold on. Are we back? No, we're not back. Hold on. We're going to be close to back. Hold on. Nope, the fan is still up. The fan is still up. A towel is on fan monitor for you so you don't have to get dizzy. Deathwater, yes, your energy and enthusiasm is wonderful, Grant. I am a towel. Justice for John O'Keefe and his family, says Jew Drops, in the lead up to this epic moment. The most epic moment that could possibly happen. So Soleil Nina says, the LOL Turtle Boy with total turtle shells crawls to the stand. Turtle walk. We must all refer to it as being turtle walked if this happens. This will define a new verb. Turtle walked. It will become a thing. Oh, I really hope the camera shows Hank Brennan being like, I call Aidan Kearney to the stand, and Kearney has to just shuffle up there like an idiot. I cannot tell you how thrilled I am. Drew Drops that Hank Brennan's about to force Aidan Kearney to take the stand and plead the fifth. Oh, it's going to be the greatest thing. It's going to be so wonderful. I don't even know if I can contain my excitement or my joy. I'm a happy little towel. You're all little towels. We're all just excited. And Diana Natali makes a good point, which is that her heart breaks for Miss O'Keefe and what TurtleBoy and Karen Reed has put the family through. As a mother that had to bury her son from a drunk driver, Diana knows Miss O'Keefe's pain and she extends her prayers for them. Yes, as much as Towell is thrilled that this moment is happening to the people who tormented Miss O'Keefe and the witnesses and the O'Keefe family, we should also remember that this is a very somber, larger case related to John O'Keefe's death, and we should honor John's memory with that somber reverence. But this is not a but to qualify what I'm saying, it's a but to point out something I said the other day. When Colin Albert and Brian Higgins, Brian Albert were vindicated in that denial of Reed's affirmation of Hank Brennan's motion to ban Reed from raising a third-party culprit defense. That was worth celebrating. Okay? That was an important moment for those people who had been tormented. This moment is not as weighty on the merits. But this moment, for people who have been following this since 2023, the spring, and have watched what TurtleBoy did to those people, if this moment is so cathartic, if this happens, if TurtleBoy has to walk up to that stand, having been forced to leave his house with 15 minutes notice and drive an hour to the court, and then he has to and the only reason he gets brought up there, he avoids the sequester, but at what cost? At what cost? He has to get turtle walked up on that stand and has to assert his Fifth Amendment rights in front of the entire country. Now, Brennan also just said right there that he is not giving TurtleBoy immunity. He doesn't foresee that happening. Which means TurtleBoy's in big trouble. They're going forward with those other cases. No immunity. But TurtleBoy will escape the sequester. But that still doesn't guarantee TurtleBoy access to the courtroom, because he might lose the attempt to get in the courtroom. He's not guaranteed to win that. Exactly. Hank Brennan, if TurtleBoy's going to plead the fifth, it's not Mr. Bradle who asserts it. TurtleBoy needs to get up there and assert it, because that's the only way TurtleBoy's getting out of the sequestration. I mean, this is the most intense thing I have ever seen in my life. I can't even, in some sense, I have gone through a lot of big motions with you, big rulings, and I've always been like, here's the context, here's why this is such a big deal, and let's talk about it. I am just flabbergasted, absolutely flabbergasted at what we are about to see collectively. I can't explain it. I've never seen it. I mean, I've heard of a Lumen Martin hearing where you assert the fifth behind closed doors, but this is a different situation because it's a public motion from Aidan. He's the movant to assert the fifth. And Brennan's saying, okay, fine, I'll let you, I'll agree. That's grounds for me to drop my sequestration motion or request for Aidan, but you have to assert it. You must assert it. And I don't think he's going to assert it. I don't know how he can assert it. I just don't see what's going to happen here. I mean, what I'm saying is I know he's going to assert it, but I just can't. I can't believe it. I cannot believe this is actually happening. I can't believe this is how this is culminating. It's such poetic justice that Aidan Kearney has no control over this. He's meeting with his lawyer now, but his lawyer is going to say straight up, like, yes, if you want out of the sequestration, you got to do this. And I mean, I'm watching the stream, folks. We're not live yet, but it's going to start any second now. It's crescendoing. It's building up. Dewdrops. Aidan Kearney is on the witness list, so he has to be sequestered for the whole trial. He can't watch it, talk about it, or discuss it. The only way, Hank Brennan just explained, the only way for Aidan Kearney to get out of that is for Aidan Kearney to go up on the stand right now and declare the fifth and plead the fifth. Murder by Maestro says, never seen this in the room before. I've never seen anything like this in my entire life. This is incredible. This is historic. This is unbelievable. It's not like the most momentous thing in the world outside of the niche group of people who follow this trial. But if you've been waiting for just a moment, if you want to enjoy your holiday weekend, if you felt that, everything is crescendoing, Aidan Kearney against his will, well, he's going to have to agree to it, but Hank Brennan forcing Aidan Kearney to drive an hour at last minute notice and now walk up on the stand in front of a national audience who knew this was the last hearing before opening arguments. Everyone is watching this who cares about this trial, and make him plead the fifth. It's the greatest thing I can imagine. I can't even believe it. We are all sitting here, front row, about to watch history. And yes, if you read this document and you'd been watching the streams, you knew Aidan Kearney was going to plead the fifth. But it's different when he gets turtle walked to the stand by Hank Brennan and has to do it live. Oh my God, I can't believe it. This is one of those things you just have to kind of be sitting around for and waiting for. You just have to, it's one of those moments. You have to know something like this might happen based on your inductive read of the documents. But for it to actually happen, oh my word. And yes, okay, it's not a guilty verdict. I realize my enthusiasm is because I'm so interested in the legal nuances of asserting the fifth, getting out of the sequester. Okay, I get it. That's a very specific niche thing to be interested in. But it is big. It's still big, even if you're only interested in that niche issue of someone having to go on the stand at the last pre-trial hearing. The last thing before opening arguments the public's going to see is Aidan Kearney pleading the fifth with Hank Brennan turtle walking him up there. Oh, I can't. Poetic justice, just everything that I could have asked for to end the pretrial process. I'm not talking about from the trial. I want to see Karen Reed get convicted, but to end the pretrial process like this. What do you mean the downside? Murder by Maestro. The downside is this is going to be the greatest 30-second clip of any courtroom anyone has ever seen in their entire life. This clip is going to get played over and 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 over again. Yes, there's an upside in the sense that he has to go up there and he can go in the trial if he wins a seat. But first of all, it's only a few weeks. So what's he win, like a quarter or 50% of the time? He's still going to be excluded for other witnesses who are the named victims in his open indictments. He's not getting an immunity deal. Brennan just said it. Oh, it is huge. Yes, there you go. Trevor McIntyre says this has huge implications for civil cases because the Fifth Amendment can be used against you. And then Sig Girl says, shower with the chef towel's kiss. TV will do anything for donos and can still talk about it, says B and Chance. That's what he's concerned about. Thought it was a closed hearing. Eva, that's a little different. It turns out that process is, I think a Lumen Martin hearing is different. It's when you're actually still going to have to testify. Brennan here is saying Kearney has made a motion to be exempt from sequestration. Brennan is saying, okay, fine, I'll drop my request for him to testify, but only if he goes on the stand and pleads the fifth. So it impacts his other cases, but it gets him out of the sequestration. It is a huge fucking cost-benefit analysis to make in 10 minutes. The difference between 4 weeks of covering the trial versus years of civil liability. Jesus Christ. I don't mean to, I'm not invoking the Lord's name in vain. I am quite literally saying I cannot, the stakes are so high right now. So high out in that hallway where they're having this discussion. No, it's not that anyone gets away with anything. It's that Aidan for right now could plead the fifth and not have to testify against Karen and get out of the sequestration order. But if you plead the fifth, like Brennan's asking Aidan to do right now, it can be used against you in civil cases. Civil, correct. Yes, murder by Maestro. Civil cases. That's what Trevor McIntyre is saying. I'm relaying the comment. that there's no doubt in my mind, Aidan Kearney, is if he goes up there and pleads the fifth, I wouldn't be surprised if all these lawsuits get launched right away. Yeah, no, Murder by Maestro, you're right to ask, and I think we can look more into it. No, nobody's really won Dewdrops. It's a very complex analysis because Aidan Kearney has to decide if he wants to be able to cover this trial. He's not even guaranteed to get in, but if he wants to be able to cover it, broadcast it, talk about it for the next 5 weeks, the price he pays is he has to go up there right now, forget about being turtle walked to the stand, he has to plead the fifth, and that can potentially be used against him in civil cases. Yep, and that's the big deal, Eva, exactly. Happy to explain. This is a big moment. I can't believe it. As I've said, I almost, when Hank Brennan had and he's exactly the type of person who would make that move. And when when Hank Brennan said, I want him, not Mr. Bradel, I want Aidan to do this, it changes the game. It's huge. You all who tuned into this just because you were utterly fascinated, the thousands of you on X and the Towel Friends on YouTube, you picked your spot. Picked your spot and hit it. Oh my word. And just so you know, it's still in recess. The second this comes out of recess, the Towel Friends are going to see it. Yeah, no, this is a big moment. Oh my God, what do I think he's going to do? He has to plead the fifth. He doesn't have a choice. Because you have civil liability whether you get up there and testify or you plead the fifth. So he's pleading the fifth. I mean, it's going to be this is the worst possible thing for Aidan. That's why this is taking so long. They're still in recess. We're 20 minutes in now. It's supposed to be 10 minutes. Ed Jobs, he can report on it if he takes the fifth, but that's the price he's going to pay. He can report on it for 5 weeks, but the civil liability could be very high. Yeah, I have no idea what's about to happen. I am hanging on the edge of my seat right now with the rest of you all. This is incredible. I can't believe this happened. I knew Hank Brennan was capable of being this wonderful, but in the moment, yes, Your Honor, if Aidan's going to assert it, I want Aidan to assert it, not Mr. Bradel. Boom. Sublime brilliance. Brilliant. Brilliant. He doesn't have to keep his mouth shut, Dewdrops, but there are consequences for taking the fifth. Yeah, it's a Queen's Gambit. It's a fait accompli, Trevor McIntyre. It's brilliant. That's why it's taking 20 minutes. TurtleBoy doesn't know what to do. Oh my God! Oh, look at the numbers jumping up on all these streams. I can't believe this. I'm watching all these different feeds at once. People are okay. It's starting. Okay, here we go. Hold on. Get ready.
That Mr. Kearney has.
Hold on.
Unmuted.
Court is back in session. You may be seated.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to assert his Fifth.
I thought you wanted a basis. No, I'm going to see Mr. Kearney here at Sidebar with just you, Mr. Bradel. And all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
That was the moment, folks. That was the moment Aidan Kearney was turtle walked to Sidebar. We won't get to see it on national TV. It is extremely unfortunate. But that was the moment Judge Cannoni, because of Hank Brennan's request, turtle walked Aidan Kearney up to the stand, up to the sidebar with Mr. Bradle, and forced Mr. Kearney on the record to assert his Fifth Amendment rights. We were deprived of the moment. The world was deprived of the moment, but we got to see the turtle walk nonetheless. We got to see Mr. Kearney forced to walk up past the bar, past Karen Reed at the defense table, and he is now standing with Judge Cannoni at Sidebar. Now, what we are going to do here is we are going to pause that recording. We are going to pause this so we don't have to watch the fan, and then we are going to wait. We are going to wait for Judge Cannoni to issue her ruling. This is going to take a second. Okay, hold on. It's done. Wait for it.
Tori, Jim?
Yes. I was contacted by a local realtor who wanted to make an offer on the property, and I told him it wasn't for sale.
Invoke that Fifth Amendment. Invoke that. All right, so Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so the court, please.
We are going full steam ahead into the Karen Reed trial, my friends. My name is GrantSmithEllis. What a moment. You saw it. You all were here for it. Aidan TurtleBoy Kearney turtle walked up to Sidebar, forced by Judge Cannoni to plead the Fifth on the record, although it was obviously not for the public record, but there was a record. That was the moment. This could have huge implications for Kearney as to civil cases going forward. Now, oh my word, Little Towel, I can't believe we were denied what could have been the most amazing moment of the trial so far, which was Kearney being actually turtle walked up to the stand and forced to declare the Fifth in public. There was now, did you notice, folks, Judge Cannoni brought up Luman Martin hearings. Little Towel was spot on. Luman Martin hearings could have happened if Mr. Brennan really pushed for it, but he felt that there was material that would have been impossible to go through in light of that context. So in light of ongoing investigations and court orders, which I thought was even more interesting. Now, what Little Towel is going to do right now is I'm searching for the exact moment that Kearney was turtle walked, because I'm going to clip that, make it into its own clip, and then just that clip of Kearney being turtle walked is what I want played here. Oh my God, was he picking his nose? No, he did not. Aidan, you did not. No, I think he was just touching his mouth. But either way, that's the shot. That is the shot. Oh, my word. So what you have to do to make these videos is you find the shot that you want to be the thumbnail preview. That's going to be sort of, you separate it out when you're doing these designs. I can actually show you all how to do this in real time. Well, I guess I don't want to empower nefarious people. But yeah, so you get the shot that you want to be the header shot, and you grab that and you make that right away just a still image. It doesn't need to, it can just be a still image. It doesn't need to be a video. And then all you're going to do with that still image, ideally, is you're going to make it fit to screen, okay? And then you're going to make it the first part of your Canva or whatever you're using to edit. You're going to make it the first still of the screen. Now, the reason you're doing that is this is what's going to show when the video actually plays for people. Whatever you have as the first still. So I'm going to reduce that in length to, I don't know, like 3.2 seconds, because you just want it to play in the beginning, the clip that you're going to use. And then what you want is you want to go into the video you're looking for. And I'm looking for a very specific segment of this clip where Aidan Kearney gets turtle walked. And so then what I'm going to do is I'm going to take that segment, I'm going to clip it, I'm going to leave it in the original segment, but I'm going to clip it. And so there's going to be a preview image of the video that's a tile. Then I'm going to grab the segment I want from the video, the turtle walk itself, and then I'm going to clip that. It's going to play after the opening, and then the full clip is going to play. And that's how you do it. That's how you build this in real time. Now, a lot of people, they would have to send this to a truck. There would be all this stuff that would go on, but not for me, because I can just do this in real time. So I have to find the moment. Hold on, I hope I grabbed the right clip here. Is this it? Yeah, I think this is it. I think we're just a little bit forward from where I need to be. Yep, here's the moment. I got it. 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 It's got to be when he's about to... There's the turtle walk. I got the turtle walk, folks. It was not easy. The Little Towel got it. No, is that too early? I need to make sure it starts. I need to make sure this is the full turtle walk, and it needs to start when he comes on screen. Nope, I need it a little bit better than that. Yep, that's what I want. And then the turtle walk needs to be, it's funny here, the turtle walk needs to stop when he is out of frame. There we go. Now, does it ever pan over to Judge Cannoni? No, the court camera pool operator would not pan over. That was smart by the court camera pool operator. Okay, so now what I'm doing is I'm taking this over here, and then I got my intro clip, I got the turtle walk, and then I got the full clip. So let's just make sure that's what we want. Nope, I didn't do it right. Oh, I see why I didn't do it right, because I just moved the clips. What I actually wanted to do was copy this, make it into a new page, and then take that very short clip, which should only be the turtle walk. Nope, got that one wrong. That's all right. I just spent so much effort getting that turtle walk too. Oh, there it is. I put it at the end when it was supposed to be at the middle. If you're wondering what Little Towel is doing, I'm rendering the clip that I just worked on that we saw of Aidan TurtleBoy Kearney being forced to assert the Fifth Amendment, and that has huge implications. And so what I'm now going to do is I'm going to render that video down. Oh, no, I want it a little bit better than that. Going to render that video down, and I'm going to upload it. And then I already have it written up, and the way that I have it written up is Breaking news, Aidan TurtleBoy Kearney was turtle walked to Sidebar with Judge Cannoni at the demand of Hank Brennan and forced to assert the Fifth Amendment on the record in front of a national audience. This has huge implications for Kearney as to civil cases going forward. So, my word, folks, it was not everything that we were expecting. It was not actually on the stand, but it was a moment. And I think it will be so interesting to the people who watch this stream that Judge Cannoni mentioned Lumen Martin, because guess what? A lot of viewers would have been like, what's Lumen Martin? But Towel viewers were like, I know exactly what that is. We talked about that during the lead up to the hearing this morning. We went into detail about a Lumen Martin hearing. We even found the case that it was from. Does that get put together in the record with a transcript? Yes, it gets recorded to FTR, but it's very protected, Trevor McIntyre, and it's for appellate purposes. Bob Alessi is not enjoying this moment, says Kerry Gold. I agree. Does he have anything to go after civilly, says Ed Jobs? Oh, I think he makes money. He has said he makes money. I don't know his finances, but discovery about Aidan Kearney's finances would be interesting. And by the way, did you know that Aidan Kearney is suing a named victim in one of his criminal cases named Lindsay Gattani? And you can use the YouTube description. If you really think what Aidan Kearney is doing is not good and you want to support the most vulnerable, do not donate to me today. Donate to Lindsay Gattani's fundraiser. You can find the link in the YouTube description. You can find the link in the pinned comment. You can find the link a number of places. It's givesendgo.com. And then when you go to givesendgo.com, the / is all uppercase GEFJ and the number 4. Now I'm going to post it in the chat again. If you actually benefited from this stream, if you thought that what Towel had to share was useful, if you care about me as a person at all, I know you all have been so kind and supportive to me, but this is one of those days where we really have an opportunity to help a good person. And this is your hour-and-a-half donation read request. Don't donate to me today. Even if you send me money, which I haven't looked at, I'm just going to give it to Lindsay. So please consider donating to her efforts. She's literally being sued by Aidan Kearney. He's tried to make a permanent injunction request to ban her from speaking. She needs our help. She needs your help. And if you truly are saying, wow, I don't like what Aidan Kearney is doing, then supporting people like Lindsay means so much, because she's a named victim in this criminal case. He attempted to sue her. Please help people like Lindsay. Her fundraiser explains why she needs the help. All the money goes directly to her legal fund, and it's all handled by third parties. I'm not even involved with the fundraiser. It's just wonderful that so many people stepped up to help Lindsay, and truly you have Little Towel's eternal gratitude for anything that you're able to do to help her. $1, $5. It's not about us today. It's not about Little Towel, even though the Turtle Walk was a wonderful moment. Please do consider supporting Lindsay. That would mean so much. And you know what I can do, actually? I can bring the fundraiser right up on the screen for us as Tal waits for his video to download, which is doing now. This is the fundraiser. Tal's asking you all to support if you'd be so kind. It's right up on your screen. Lindsay Gattani's a wonderful person, and she actually wrote a thank you note that we can see here on the screen, and I'll bring this text up and make it legible. And again, the donation link is in the comments. It's in the stream description. This is Lindsay Gattani's fundraiser, and her friend is helping her, and her so many wonderful people have stepped up. Lindsay has full control over the fundraiser, and it really goes to help her in her fight against TurtleBoy, and to stand up for herself and be able to protect her family and provide legal service and get legal services. And Lindsay on January 21st was able to write a thank you note, which I'll read for you all because it's public. It's just up on the fundraiser. I want to thank, and again, this is related to Aidan TurtleBoy Kearney, because although we just saw that ruling, this is truly very important. I want to thank everyone who has been kind enough to donate to this fundraiser, and just pause for 1 second here as I get this thing out of the way. And if you're wondering, what are we reading? We're reading, what? I didn't ask you to go away from that. Oh, it just loaded a new part of the page. That's exactly what I was doing, so give me 1 second. If you're wondering, TurtleBoy pled the fifth in a moment of just intense drama a few minutes ago. And I am using this opportunity to ask you all not to donate to Little Towel today, despite the fact that Little Towel has so much going on. I'm asking you to, if you are thinking about doing anything like that, to instead send your support to a very worthy person whose name is Lindsay Gattani, who is fighting a number of ongoing battles with Aidan Kearney, and I seriously am very grateful to anyone who has considered supporting Lindsay in her efforts. And as I was saying that, of course, my download didn't finish. I want to thank everyone. This is Lindsay's words of thanks. I want to thank everyone who's been kind enough to donate to this fundraiser. This is from January, by the way, earlier this year. The messages and prayers that you have sent have given me strength and hope to keep going. I have read them over and over, especially in recent weeks when it's become difficult to see the sun through the clouds. It means more to me than you will ever realize. I want to specifically thank my small circle of friends who have been the subject of personal attacks simply for organizing this fundraiser and standing up for the truth. They gain nothing by trying to help me and certainly don't deserve the onslaught of harassment they've received. I will always remember these friends who have stood by me in my darkest times when there was zero benefit for them doing so. It's not very often that you find friends like this in life. Which brings me to something that I need to address. This is and always has been the official and only fundraiser created in my name at that time. There was some in the past. This is much more than I would like to say and address, there is much more that I would like to say and address, but right now I'm going to leave it at that. I will not engage or reciprocate in the disappointing behavior that has been taking place. Most intelligent people can see what is happening anyway. This past year has taught me a lot, and I've seen the absolute worst of humanity. This is Lindsay speaking. My children and I have been the subject of vicious harassment and complete lies, betrayals from bad actors who pretended to be my friends, deception from people who never had my best interest in mind, death threats and wishes of harm, disappointment in people whose job is to protect and uphold the law, and frustration with the justice system, which I've come to learn is not about justice at all, but rather about who you know and what strings you can pull. Weeks before my latest hearing to renew my restraining order, I had decided to step back from social media. This has been the best thing for my mental health. I will not be returning, at least not for the foreseeable future. I can't change the opinions of people who have no interest in the truth. I know who I am. My children know who I am. We know what we've experienced, and I know what I stood for. The people who have intentionally hurt us will have to answer to God someday. I've experienced a lot in my life, but I was blessed with an amazing gift, the ability to persevere, even in the toughest of times. Giving up, though it often crosses my mind during moments of weakness, is just not in my blood. If you have the ability to donate, every dollar helps. I intend to continue this fight against evil with everything in me and teach my children the importance of standing up to bullies. Public smears and lies by heartless people who take pleasure in the suffering of others will not deter me. If you're not in a position financially to donate, please consider a prayer. The power of prayer is real. I agree with that, Lindsay. Thank you for all of you who show compassion, empathy, selflessness, and a desire to see good triumph over evil. The truth will eventually be told, and those who have intentionally caused harm to others will be held accountable in this lifetime by means of the law, or in the next lifetime when they face God himself. With all gratitude and love in the world, Lindsay. And she closes Luke 23:34. And Jesus said, Father, forgive them, for they know not what they do. And then Lindsay says, edited to add, at this point in time, this is and has been the only fundraiser. There have been rumors swirling around that this fundraiser was not approved by me or that there was another fundraiser created by somebody else. This message is to clarify that currently this is the only one that has been approved. There have been two fundraisers in the past, one for the hearing in which someone tried to vacate my RO. An attorney was retained and paid $8K in an $8K retainer, which I can confirm. That lawyer was paid in full. The unused retainer was returned at the conclusion of his representation. $2K was then rolled over towards her next attorney who represented Lindsay for a Rule 17 hearing. That attorney charged a flat fee of $4K. The $2,000 unused from the previous attorney was put towards that, and an additional $2K was raised. There were no unused funds from those first two, and this is a new fundraiser starting at zero. Lindsay needs your help. She explains in this fundraiser why she's being sued, what she's fighting, and why she needs the donations. And let me just say, Little Towel would be eternally grateful if any of you would consider, in honor of anything you may have learned today, donating to Miss Gattani and showing that people are not alone, and that there's good people out there who are willing to stand up, whether it's against Aidan Kearney or any other type of insidious forces, and protect and honor and revere and respect the most vulnerable among us. And by God, if you can do that, whether it's in honor of Little Towel or what you feel is right or justice, then I implore you, please consider doing so. I'm going to read some of your comments now. I apologize for taking a little bit of time to go on my soliloquy. I appreciate those of you who tuned in. I appreciate those of you who stayed with me to watch what was a series of very interesting developments. Sig Girl said it would have been interesting to see Kearney forced up on the stand and misstep. Do you think Kearney was banking on getting a deal? Yes, Macy, I do, and I'm going to actually add that to my post. Thank you for saying that. It was also announced earlier that Kearney will not be getting immunity. It was also announced earlier by Prosecutor Brennan, that Kearney will not be getting an immunity deal of any kind. That's actually a huge deal. And then I have to actually, I realized and it was important to me. I wanted to write up Lindsay's post first, and I'm very hungry, but I'm going to get all this done while I'm reading your comments before we get out of here. Kearney will not be getting an immunity deal of any kind as to his open felony witness intimidation, wiretapping, and conspiracy indictments. Okay, as to his open felony witness intimidation, picketing, and conspiracy indictments. Okay, and then I'm going to say, although this move allows Kearney to apply to attend the trial as media via a lottery that he may not win. I have a bad habit of reading a viewer comment as I'm writing a story and then saying something like, oh, that is a fascinating insight as to what I should include in the story that I'm writing up. So you all, this is a collaborative effort. I want to thank you for inspiring Towel. And I really need to get my microphone stand fixed because I have one that attaches to my desk and I can't get it off my other part of my desk, and I don't like typing like this. As much as some of you enjoy watching Towel giggle, sometimes Towel giggles are absolutely a manifestation of frustration. Although this move allows Kearney to apply to attend the trial as media via a weekly lottery that he may not win, Kearney is still banned from the courtroom whenever a witness in his cases testifies against Reed. Oh my word. What a moment. What a moment. This just fascinating all around, folks, and you all saw it happen in real time. You were the Towel friends who heard the crescendo coming. Judge Cannone saved Aidan the embarrassment of having to do it on the stand, but Aidan still had to make that Fifth Amendment plea at sidebar. And Little Towel is now working on getting the final video out of the day before we wrap things up. And then I also want to say this was quite literally the most... Oh, God damn it. Now I have to wait for that sentence to finish typing. I feel like I overdo my little computer. This was quite literally the most intense last moments during a pre-trial hearing on the eve of opening statements that I have ever seen. The story, and now I'm going to finish it by saying the papers will read, TurtleBoy caves, pleads the Fifth. The headlines going into the retrial, TurtleBoy caves, pleads the Fifth, Brennan poised to pounce. The headlines this weekend, TurtleBoy caves on national TV, pleads the Fifth, Brennan poised to pounce. Retrial days away. I should be a 1920s newspaper headline writer. Someone send me back in time like we were discussing earlier. I can write old-timey newspaper stories. I can switch my style through eras very easily because I have all these different memorized like historical records, just random news reports about things like Missouri wrestling in the 40s, or like World War I lead up, or Federal Reserve lead up, or Panic of 1907 or 1893, and then I'm just like okay, I can just take on the language that the people who were speaking at that time would use. The headlines this weekend: TurtleBoy caves on national TV, pleads the fifth, Brennan poised to pounce, retrial days away. I'm correcting my capitalization. The headlines this weekend: in the worst possible way for Reed's ill-fated, fleeting defense. I enjoy bringing you all into the writing process. I think we've done a few drafts before, and as soon as I get this up, we're going to read some of your final comments. We're heading into the retrial. We're going to do some more streams over the next few days. I have some people who want to do mock opening arguments, and I think we can do it well on this channel with all the viewer engagement. We can have you vote on which side you liked for each argument. I have some plans for that, so give me a few days. The headlines this weekend: in the worst possible outcome for Reed's ill-fated, fleeting defense. Do I have to put a comma after ill-fated? Yes, I think I do. Ill-fated, fleeting defense. TurtleBoy caves on national TV, pleads the fifth, Brennan poised to pounce, retrial days away. And let me just make sure this is exactly what I wanted. Yeah, and then the video shows him getting turtle walked up in the beginning. And then let's just make sure the turtle walk is still in the middle of the video. Perfect. Done. Did it. Got it written. Almost can get back to your comments now. I know you all sometimes see it in real time, but I think it is a lot and yes, I can do it sitting down, and I know I have some experience with this, but it is a lot to process all of these clips, write them up, upload them, record them, synthesize them, edit them in real time while still doing a live stream. And I apologize. I wish I could read your comments as I was doing that, but writing up the story, I can't reading your comments to help me supplement the writing of the story was great, but I can't read your comments and write the story at the same time. So that was the full summary of the hearing. That was very interesting. All right, let's get back to your comments. TB is back there stomping his little feet. I'm so upset about this case, and for Peggy O'Keefe, says Drew Drops. I agree. Justice for John O'Keefe and his family. I agree. What if he chooses? I thought Hank would want to keep him out of the courtroom. Well, Hank Brennan it's a delicate balancing act, but I think Hank Brennan if you plead the fifth, that's for Hank Brennan's right. You plead the fifth on the record. That has implications. Okay, it also means that you can get out of the sequester. AJ is worried about those independent readers of the text messages, although Brian Higgins read his text messages with Karen Reed last time, and that was explosive, so I don't think it can get worse than that. TB will have Meredith run it all. There needs to be another motion on any third parties. A gag order should be initiated by the judge. What say you, Grant? It's interesting. He didn't get sequestered. Trevor McIntyre says a civil case, a judge or jury can draw an adverse inference if a defendant pleads the Fifth Amendment. In a criminal case, meaning they consider the silence as evidence of guilt or liability. That's huge. The towel must join the shower soon after this epic moment. It was an epic moment. Who's on the witness list? TB can't be there for. It's Chris Albert, Julie Nagel, Jen McCabe, Matt McCabe, the niece and nephew. It's like 9 people total. The presence of Aidan makes the meeting. The presence of Aidan makes meeting the shower a necessity. Yes, it should have been on the stand like every other person in Massachusetts. It's a bit of a unique situation, so I'm not really positive. What about consciousness of guilt? So that motion can be made at any time it gets made. You want a good evidentiary record. It can be made at any time, and then the instruction comes after the close of evidence. So the consciousness of guilt motion, watch for it. It can come any time. What did she do to him? There's not much on the fundraiser page. Oh, Lindsay is a cooperating witness in some of the open felony charges against Aidan. Aidan was actually had his bail revoked after going to Lindsay's apartment on December 23rd, 2023. Aidan had told Lindsay about a lot of his conversations with Karen Reed, and Karen had told Aidan about her connections with Josh Levy and the federal government. And so as a result of that, Lindsay was a precipient witness between October of 2023 and December of 2023 to the nature of Aidan and Karen's communications, and Lindsay is the named victim and obviously a witness in Aidan's open criminal cases. And so Aidan, I think because Lindsay learned a little bit too much, Aidan has just tried to smear her. Aidan has tried to talk to her family members to get them to smear her, just the lowest of the low. And this woman, Lindsay, is a resilient, beautiful human being who has just inspired Little Towel to grow and be a better person, and is just a wonderful mother and just the most amazing person you can imagine, tormented by TurtleBoy. So please consider visiting the fundraiser, supporting it. Trust in Little Towel when I tell you that donating to Lindsay is more important than donating to Little Towel. And anything you want to say thank you to me today, don't send it to me. I'll be okay. I can eat my peanut M&Ms and Cheez-Its. I'll be fine. Send it to Lindsay, please. I beg you. It would mean so much to me. Lisa Cox, there's a lot that happened. You're going to have to watch the full stream. The TurtleBoy Fifth Amendment moment was definitely the biggest. That's the headline. That was huge. It's not really confusing. Jew drops, I'm trying to explain it. What it means, and Trevor McIntyre did a good job. It means Kearney can get off the sequester, okay? He's not going to have to testify against Karen now. But taking the Fifth Amendment in this way has implications for Kearney as to his civil lawsuits going forward. This makes TB walk on thin ice in regards to his many civil cases. Yeah, I agree, Solinina. Huge if they come down. I don't hold the justice system in Massachusetts to high standards, says Kerry Gold. The Jason Davis case is tragic and shows just how corrupt the state is. I'll have to look more into that. B and Chan says, can we all hope a second grand jury was reconvened about TR and Karen Reed of witness intimidation? You could certainly see that happening. She's going to walk free, Jewdrop says. I don't know about that. Rest in peace, John O'Keefe. I agree about that. B and Chan says, not this time, Jewdrops. Have a blessed day, all, says Angela Whittick. You too. And Angela Whittick sends her regards to Towel friends and family. Murder by Maestro says, Jewdrops, don't be sad. This is a good day for the victims of Aidan. Yep, it's a big day, big day. I'm beyond disgusted with the judicial system in Massachusetts, says Eva. No one, and I mean no one, would skate on what he's done without penalty. Maybe there will be judicial penalty. Take care, says Kerry Gold to Angela Whittick. Recap of the day, Lisa Cox. There were about 5 or 6 outstanding motions in limine. We can take a look at them quickly. Let me just scroll you through the Twitter, and we'll be able to look at each one of the developments and then conclude up at the top, and then I'll play you as an outro the Turtle Walk video. So what were the updates of the day? Where did we start? We started so long ago, all those hours ago, 11 a.m. Felt like just 5 minutes. So the hearing started late. TurtleBoy got called in. We started with motions about Canton CPD videos. The state and Reed are going to work on that. No ruling. Then we found out that there is map data from Karen's Lexus infotainment and GPS system. And we can take a look at this clip because it absolutely shows that map data could be devastating for Karen as to her time and place. So give me 1 second. And if you missed today's hearing, we'll do a quick recap, better than watching the 1 o'clock news, if they even do the 1 o'clock news still. But Towel's hungry, so we're going to do this quickly. All right, let's watch what happened. Oh, I have to unmute the tab. Give me 1 second. All right, let's watch what happened related to this situation, which I just described and then forgot. Oh, yes, the GPS data. This is huge. Let's look.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it, we have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank you.
Your Honor.
Okay. So
it was a map. Oh my word, Murder by Maestro. Hank Brennan's expert has a map from Dr. Welcher, which is going to show location data of Karen Reed's car. We knew it. We knew it was coming. This is the new information from the chip off. Everything is crescendo to this moment, and it really was that data, the piece of paper that I zoomed in on earlier. Murder by Maestro. Again, my friend, nailed it on the money. God bless you. Much love to you, sir. Let's continue watching the hearing. I just clipped this. I'm going to post it now. So you saw it there. I mean, I'll show it to you one more time. That is potential evidence right there when I had it zoomed in. Hold on. There it is. That is definitely a map of Fairview, and it's Dr. Welcher's report. And if that shows Karen's time and place at 12:31 a.m. on 1/29/2022 or 5:23 a.m. when she went back to Fairview allegedly, it's a game over. Look at that map, folks. Look at that. That's Fairview. That is it. That is the map. Bad news bears for Karen Reed. And we did have a request, I think, for an overview. Hi, Jimbo, by the way. Great to see you. Glad for dropping in. If you missed today's hearing, we're just looking over this. The dog bite expert, Karen Reed's dog bite expert, was also the motion to reconsider allowing Hank Brennan's expert to comment on Karen Reed's dog bite expert and her ludicrous conclusions. It looks like it's going to be denied, the reconsideration. Hank Brennan is able to argue for showing that's Dr. Crosby, I think, that his expert, Dr. Crosby, can show that Chloe, the dog, did not bite John O'Keefe. And as there's no dog DNA in the case, we knew that already. But that was that motion. And then this was when Karen Reed found out that her statements from media interviews are going to be included in Hank Brennan's opening.
Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times.
Oh yeah, then there was a long debate about this independent reader, and Alan Jackson does not want it.
Which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked.
So then we see some objections, and then we end up finding an independent reader is probably going to happen. And then this was the moment related to ARCA. We're not going to watch the full thing, but Brennan sternly lectured Karen Reed's attorneys for not complying with reciprocal discovery. It was a big moment of the hearing, definitely worth watching. Brennan's point was that he's very concerned this is exactly what happened last time, and that Reed's attorneys may be trying to hide the ball.
So,
secondly, there are two issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery.
Yep, so that's basically the sum of Brennan's argument, and then here's where the fireworks start.
Filed, so This is not unusual. A party says we asked for all 13, another
has
You're right,
anticipated and tried to prevent. Mr. Brennan do not have additional
things that are normal cross-examination.
Disagree with that, Dr. Rim. At the same time,
Brennan's response.
There's communication, and I will emphasize it here. Well, they can certainly testify
on what you find
Custody control.
So for which one?
So there was a moment where Brennan stood up. I hope I ended up saving it and said, yeah, it was this one actually. Where Brennan says, this was exactly the thing I was worried about happening.
Information.
I want to get that moment.
The fact that we were only provided access to hire ARCA on September, I'm sorry, on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, the fact that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush.
And that's exactly what Brennan's worried about this time. And then, yeah, so that was the close, and then we went to recess. We came back, and we got the ruling on the IA findings, which can come in, but they're limited. And then here is Brent. This was the moment when Brennan tried to get TurtleBoy to go up on the stand, or at least announced it. Then we took a recess, and then this was the moment, folks. This was the moment, the moment of the day. The headlines: Aidan TurtleBoy Kearney turtle walked to the stand, forced to take the fifth during a criminal trial. Let's watch it together. That was the moment, folks. That was the moment, Aidan.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to consider his Fifth.
I thought you wanted a basis. No, I'm going to see Mr. Kearney here at Sidebar with just you, Mr. Bradel. And all recording devices are off. FTR goes to sealed, Tori and Chrissy.
That was the moment, folks. That was the moment. Aidan Kearney was turtle walk to Sidebar. We won't get to see it on national TV. It is extremely unfortunate. But that was the moment. Judge Cannoni, because of Hank Brennan's request, turtle walked Aidan Kearney up to the stand, up to the Sidebar with Mr. Bradel, and forced Mr. Kearney on the record to assert his Fifth Amendment rights. We were deprived of the moment. The world was deprived of the moment, but we got to see the turtle walk nonetheless. We got to see Mr. Kearney forced to walk up past the bar, past Karen Reed at the defense table, and he is now standing with Judge Cannoni at Sidebar. Now, that was great. I was thrilled we all got to see that together. Dewdrop says, thank you, Grant. It was great to see you all. Happy Easter. Yes, truly, God bless you all. Happy Easter, Sole Nina. I know some of you have already taken your leave. It's great to see you, Jimbo. As I said, Murder by Maestro, I just saw your Twitter post. You're the best. He says, I told you. Why don't towels get lost? Because they know how to wrap things up, says Angela Wittick. I do, but I have to read all your comments. Thanks for the recap. Yes, Lisa Cox, that was for you. I was going to end the stream, but I was like, I'm tired and hungry, but Lisa asked, I'll do it. But yes, thank you, Lisa, for asking. Judge Cannoni must keep this defense in line. Yes, I agree, Angela Wittick. I think Murder by Maestro is a time traveler who also has off-world powers. I agree. Angela Wittick, after watching her today, my faith has plummeted in Judge Cannoni. We'll see. JA5 says, what's good about it, though? Isn't Arca and TB bad for the CW? No. Arca is absolutely horrible for Reed. They're going to very much look like they were in the bag, and they're going to get humiliated. TB would have been very bad for Reed as to consciousness of guilt evidence. So TurtleBoy being off the witness list will let her breathe a sigh of relief. But obviously the civil implications for TurtleBoy by declaring the fifth are huge. The Hankinator strikes again, says Angela Wittick. Lisa Cox says, wow, TurtleBoy is a loser. That's your opinion. The first time the blogger had nothing to say, says Jeff Williams. Jeff Williams, it's so good to see you. You're certainly right. And you get, as one of our last acts, you get made an honorary towel for sticking around till the end. Murder by Maestro says, JF5, I think the giant leaps the defense made pre-trial first time have been reduced to small steps. Yes, no giant leaps for Karen Reed kind, small steps for the turtle, and towels on their way to lunch. None of it could be unwrung, I agree. We must always cling to our hope and faith, says Angela Wittick. Eva, we hang together. That's true. People get persecuted for their faith a lot. But I have faith in you all and your ability to go out and do acts of service. I didn't check my phone all stream. If you sent any donations, I didn't see them. I'm so sorry. I'll reply to them if they are there. As I mentioned, I will, even if you sent money, and unless you specifically said, Grant, this is for you, but even then, I'll donate it forward to Lindsay. Anything that comes in, and I'll take a look at that Give, Send, Go a little later today. Seriously, it really means a lot that you even listen to me ask for support for Lindsay, and don't give anything to Little Towel today. This was my act of service for you all. Pay it forward in whatever way you want. Go give away tomato plants, go love someone, and go show an act of kindness. Whatever you can do, it would mean so much to Towel. And just know, when you send a $5 donation to a Give, Send, Go for a victim, they're going to read that and they're going to think, oh my God, someone out there is thinking of me. Like, I mean something. I'm real to them. And do that for Lindsay today, please, for me. I'm going to send her some money on a Give, Send, Go right now. Towel loves you all so much. My friend, the time traveler, ARC are changing their opinions, says JI5. No, they might not be allowed to, JI5. They can try to introduce new evidence, but there's going to be a mid-trial voir dire before ARCA can testify, and ARCA might be subject to court order to bring documents to that mid-trial voir dire, and it has to do with their credibility, so we have no idea whether ARCA is going to testify, change their opinion, be allowed to testify to anything but the original February 2024 report. All of that is up in the air. No decisions have come down yet. We'll take a look at the docket throughout the day and see what comes up. Welcome, Jeff Williams. Murder by Maestro says, welcome to the fold. Whoop. Wondering what TurtleBoy will say on his channel about pleading the fifth. He'll find some way to excuse it, and he'll say, you got to plead the fifth when you don't agree with the statute. But really, the media will see it for what it is. Thank you, Grant, says Angela Wittick. Much love and respect. Much love to you, too. Thanks, Grant, says Lynn. Take care. Grant, you are so kind. I'm happy to help Lisa. It means so much to me. And now I'm going to get to go enjoy a great lunch, and then I'm going to sit around and think, I did an act of service today. It made me so happy, so know that I was happy to help you. Lisa Cox, TurtleBoy will use it as a win that he can go into court. He's not guaranteed to go into court. He can enter the weekly lottery. Maybe he gets in, maybe he doesn't. No guarantee. All right, folks, we have made it. Let folks go to lunch wherever you are in the world. My name's GrantSmithEllis. It means so much to me you stayed with me this whole time. Please, as I said, go out there and do an act of service. Go do something kind for your friends. Love other people around you. That's what it means to take back this world from a sordid conflagration of self-interest that has risen and dominated soft power realpolitik by preserving, demonstrating, and expanding ruthless self-interest at the expense of communal good. But we can turn that around. We can introduce a new soft power political dynamic based on preserving, expanding, and demonstrating universal love for one another. And that's what I'm going to do today after I go eat a sandwich or some pizza or whatever I can find. God bless you all. My name's Grant Smith Ellis. Thank you too. Until next time, be well. Enjoy the rest of your Wednesday. We got a big few days coming up, and you'll definitely have some more streams with me before the Karen Reed and John O'Keefe retrial begins on Tuesday. Keep your thoughts and prayers more so than anyone else with the O'Keefe family, the witnesses, everyone impacted by this trial. Keep them in your thoughts and prayers. And please, let's see a conviction for Karen Reed on at least one count for the actions that she did, in my opinion, that led to the death of John O'Keefe, a great man taken far too soon from this earth by an ignoble woman far more interested in fame and clout than accountability. Until next time, friends, my name's Grant Smith Ellis. God bless.